You have to make a decision. And I'm talking to you guys about this. Do not become a litigator in court if it's not for you. Of course, there is another way you can do it. You can become a litigator, but always use an advocate to fight your battles in court. Because you get juniors, they are cheap, they don't ask a lot of money. You can set yourself up and you can be part of the fight. You can be part of the fight. In criminal courts, you can always go and sit beside your attorney of record. In this civil litigation, you can sit beside him. You can even go to motion court if you want to, although I wouldn't recommend that. There I will, because the motion court's very busy, and most attorneys of records don't go there. All right. There on page 124 going forward, we're talking about separation of issues this morning. Rule 33. Rules. Ladies and gentlemen, if you're going to become a litigator, you got to know your rules. You must know your rules. You must have Buckle or Erasmus or all these books. You must have them, those thick ones that cost 10, 20,000 rand, because they have all the commentary on the rules and the sections of the Act where that is relevant. And that is so important. You won't believe that how many times I had a book like that in my legal suitcase, and I'm arguing in court, and the opposition jumps up and they sidewind me. They surprise me. They not hijack, they, what do you call it? In any event, I'm caught off guard, ambush. I'm looking for the word ambush. They ambush me. And I have these books in my suitcase. One attorney one day said to me, "Where does all this book suddenly come from?" And I said, well, it was in my suitcase, in this interlocutory and interpleaders criminal cases also. And those books you rip out, you quickly page to the relevant section. Sometimes the judge would ask you, if he sees you have that book with you while you're arguing, he would say, "Can you just hand it up to me? I also want to look at it, and he can make an immediate ruling on the matter, because he has also now your book in front of him." So those things are important. All right, let's look at separation of issues. If it appears to the court that there, by the way, ladies and gentlemen, by the way, before I go further, where's that book? Oh, here it is. Here it is on my table. If I could give you a word of advice, make a note there. Always, never walk into court, criminal court or civil court, without the Bill of Rights Handbook by Ian Curry and Johan de Waal. And the last one that was printed, if I'm not mistaken, is the one, I've got them all actually, is the 6th edition, the Bill of Rights Handbook, Ian Curry and Johan de Waal. Now, it's a thick book about constitutional rights, chapter 2 there, of the Constitution, and it runs almost up to 900 pages. But you can get it from Utah. It's very expensive. The Bill of Rights Handbook, Ian Curry and Johan de Waal. So from Utah, the 6th edition is the last one that came out. And I really want to impart on you, get that book. I never walk without that book into a court. You've got no idea. When the opposition start pulling out tricks and it goes into a constitutional direction, you have no idea how that book has saved my life. I said to the adjudicator, well, this is new. Can we just stand down for 50 minutes to see where we're going to go with us? And they will always grant that to you, and then you run with it. That book has saved my life many times, because out of that book, at least 80% of the time, I can formalize a constitutional argument to say, no, this is not up, this is bullshit, blah, blah. Of course, I don't use the word bullshit in court. Can you imagine that? I did do something in court one day. Let me streetwise you again. I said I was busy with cross-examination, and I said to a very difficult opposition witness in the box, "You are lying. I submit you are lying, sir. That is a blatant lie." And the adjudicator on the bench had a heart attack. You cannot say to somebody they are lying. That you cannot do in my court. You have to say it in another manner. And then I had to say to him, he's still lying, but I had to come around and say that that submission is highly improbable, and I had to go in a direction like that. So please don't make that mistake. It was a big mistake in front of a very good adjudicator. A lot of respect for him. He almost had a heart attack. Yeah, we can't do that in my court. You can't say somebody's lying. That's for me to decide. So if you're going to make a submission like that, you got to do it respectfully. You're actually insulting the person. So yeah, so I learned to throw a curveball. Let's look at separation of issues there. Rule 33. It appears to the court, if it appears to the court, there on page 124, if it appears to the court that there is a question of law or of fact that may conveniently be adjudicated before evidence is led, or separately from any other question, the court may meru motu and shall, on application of any party, direct a separation of issue unless it appears that the issue cannot be conveniently be decided separately. And that paragraph, I have to submit to you respectfully, actually says everything. Must the books be hard copy or can I have my device in court is a question that came up. You can have your device in court, that's no problem. At the end of the day, the adjudicator must go to his own library. Very good question there. We all have this. What do you call it? That person that asked the question, I suppose you have one of these pads. What do you call those pads? These big pads. And they are brilliant. Oh, yeah, that's right. President Ramaphosa's pad was stolen. I suppose you have one of those pads. And yes, you can have those pads there. They're quiet. You put the sound off. They're not bulky. And what's nice about what you're asking me is you don't build muscles like me. You don't drag in all those books with you. You have your electronic device there. I'm an old dinosaur. I have 3 of those pads. I don't use it. Can you believe it? My apologies for that. And so, yeah. No, absolutely. Good question there. And you have all that electronic power data. Or you can link online there in court. Yes, you young guys. Where are you coming from with all these new things? I'm still one of those old dogs. I have this habit. If I open a book, I put my nose in it and I smell it first. I don't think I'll be able to do that with the screen. Yes, my answer to that is yes. Absolutely yes, it is the future. Okay, let's look at the court case there. They have one court case there. Let's have a look at it and read it. Grootboom versus Graaf Reinet Municipality of 2001 is quite a well-known case. In the case of an action in terms of a Compulsory Motor Vehicle Insurance Act or the MVA or the Multi-Rattle Motor Vehicle Accident Fund or the RAF of 1996 as amended of course, and on application of a party to such action that a question of liability, the merits be decided separately, a court can decide a separate the adjudication of the merits and the determination of the quantum. And I'm not going to go further because here I'm just going to teach you something. What usually does get separated is the merits and the quantum. People say, okay, we're going to finish the case on the merits and we'll decide the quantum later. But, make a note there. There's a lot of judges that don't allow it. Again, Judge Southwood, we spoke about him yesterday. Brilliant judge. You can forget it. You can forget it. That's going to happen in most of your cases because the justice says it's a waste of time. We can adjudicate it on the same time. Why can we not do it? So if you want that done, the quantum and the merits to be separated, what is the quantum? Yes, okay, I hear a lot of you are screaming at me there in your minds. What is quantum? Well, quantum is, let me give you an example. Let's use defamation again, and suddenly you want 250,000 Rand because somebody called you a beep, whatever. And that's quantum. Quantum is the amount you're asking there. Quantum is that, and then that goes into a fight on its own. But the adjudicators don't like it. They call it a waste of their time. So you're going to have a good reason for that. All right, let's going on. We don't want to stand too long still on these things. It's 09:15. 10 o'clock we'll break for that short 15 minutes. So let's go on. There's a couple of court cases you can go on read there. I'm not going to read all of it to you. If you go on page 125, they say there at the top the following considerations, which are not exhaustive, should be kept in mind when considering the application for separation of issues. And that's important to you because what we are teaching you is then now the words. This is the arguments you're going to use to convince somebody that you want to do this. A thorough evaluation of the pleading should be undertaken to determine what the issues are. I mean, you cannot ask for a separation of issues if you don't know what the issues are. Having determined the issues, consider whether there are issues which may conveniently be decided separately, and which, if dealt with separately, will shorten the duration or facilitate the determination of the action. And that's what most of the judges are looking at. If you ask for a separation of issues, most of the time, there is not going to be a shortening of the periods. As a matter of fact, it can be longer. And that is the bench's argument usually. In making this determination, the litigant must keep in mind the nature of the cause of action and or defense relied on, and the various elements required to be proved or disproved, and then practical considerations such as the length of the trial of all issues are dealt with at once, as opposed to one where the separation as ordered should also be considered. So yeah, that's where they want to do. Most of the guys on the bench don't like this issue separation thing. They'll only allow it if it's necessary. There's two ways you can ask for this. You can ask in court for this, but I don't like doing that. In the years I've been practicing, I'd rather go and test the adjudicator, the judge, in his chambers. Walking there, shake his hand, and I will ask him, I want to do this, and this is my reasons. Is he amicable to it? Or is he one of those justices that puts his foot down, he doesn't believe in it, and then I don't have to waste my time. So that's the situation. Sometimes you have clever clients, like I said yesterday, very clever clients, big businessmen. They know sometimes the law better than you. And if they instruct you that you must do it, then of course you don't have a choice. Just get it written down somewhere that it is an instruction, in spite of the fact that you had advised them that this judge don't like doing that. So just cover yourself. Always cover yourself. If you cover yourself, that is great. Preparation of court papers. Yeah. Especially in the motion court, but all the courts. But I told you the story yesterday where the judge was swinging the file around in the air because he saw I was going on like a Ferrari in the motion court, bringing this divorce. He was not going to be able to intervene. He started waving the file at me, and there was nothing in the file. So you always make certain these things are in order. Let's have a quick look at it. It is the duty of the plaintiff's attorney to arrange and paginate and bind together all delivered papers and to deliver a complete index thereof at least 5 days before the hearing. In practice, it means the following. All pleadings are bound together and numbered consecutively in one bundle, and then such bundle is indexed. All notices which are filed at court are bound together and numbered consecutively, and then the bundle concerned is also indexed. Copies of both indexes must be served on the other party or parties. It's not to say there's only one party. Handwritten annexures to pleadings or notice should be retyped for easy legible. If voluminous, the Rule 39.6 summaries should be bound, paginated, and indexed. Please take note of this. If it's voluminous, you have to type summaries there. You have to make summaries available there. A lot of people don't know it, and then they get into trouble. If at a trial a variety of other documentation is going to be used, like for example, documentaries of proof, such papers must be bound together in a bundle, numbered consecutively and provided with a separate index. And that is very important in terms of what I'm bringing under your attention now. Please, ladies and gentlemen, just a quick tip before we go on. If you don't know how to paginate, don't go and do it. Because I know a lot of principals just say, hey, go and paginate. This is how you do it. And they quickly explain it to you. Let me tell you something. If you make a mistake on pagination, everybody's in trouble. What happens with a wrong pagination number? You're in court, you're fighting this, and you look up to the bench, you say, my lord, I respectfully submit that this and this. May I respectfully request this court to page number 25 of the index bundle, so and so and so. Everybody runs off there and everybody gets to something different because you've mucked it up, or they don't get to what they're supposed to be getting to. And that's what it's all about. So if you don't know how to do it, ask your principals 1,000th time, or get a good example to take with you and use it until you always know how to do it. Principals throw this out to the candidate attorneys because they think it's inferior work. I've seen in a court case where the judge stops the proceedings and chase everybody out of court because those things were not right. All right, you can read further there on page 126. I'm going to move on there to evidence on commission, paragraph 18.8. A court may, on application or notice in any matter where it appears convenient or necessary for the purpose of justice, make an order for the taking the evidence of a witness before or during the trial before a commissioner. So yeah, I'm not even going to talk about that further. They can do it. That's what I can order, and that's very good. I am going to say something. Listen up. Don't get into shit about commissioning documents. I have caught many attorney committing fraud. And the first place I catch them is on the dates. Committing fraud on commissioning documents for friends, etc., in court cases. And one of the first places I catch them is on dates. I look at that date they commission it. I look when it was issued. I look in the affidavit, usually in the first sentence, sometimes they say when the affidavit was made. And I look at everything. I'm one of those old guys, those dinosaurs that looks at every little thing. And you won't believe how many attorneys I have caught in mucking around with a commissioner of oaths. Don't do it, okay? Make a note there, don't do it. Don't bugger up your career over bullshit like this. Usually the court does nothing about it. You can win your case on it. Usually they don't report the people that makes themselves guilty of this. But here and there I've seen a judge take exception, and he reports them in the past to whatever forum he reports them to. Can even open up a criminal case against people that do that. So please, 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 I have an eye for detail, and I've caught so many people. And then you phone the opposition, say, I've got you. You, sir, made yourself guilty of this. And now, I'm afraid I have no choice. If we go on trial, this is going to be an issue. Phone me back and tell me what you want to do about this, as fast as you move to a settlement agreement. Now, ladies and gentlemen, be careful. You cannot blackmail people. A lot of you are saying, aha, got him. I'm going to report you if you don't play ball. No. You phone him, you bring it under his attention as a professional colleague. You say, hey, I got you. What the hell did you do here? If we go on trial, all this bullshit is coming out. I'm going to give you a day or two. Let me know what you want to do about this, because, I have to defend my client. Instructions are instructions. And then he'll come back, and a lot of them come back and say, oh, I spoke to the client. No, it's not a big deal. I still say I didn't do it. They will never admit it. And they'll say, but the client, I've got new instructions. The client wants us to settle now. What nonsense. But that's what happens. But yes, so be careful that, but you cannot blackmail people. Hey, if you don't settle, I'm going to do this and this. Choose your words right, write your letters right. You cannot blackmail, because then you are a bad legal practitioner. Think how you say things. It's the same if you're married, especially if you're a man, you're married as a husband and a wife. Think what you say to your wife. You can just get into trouble if you don't choose the right words. All right. Let's move on. We're not here to talk about the psychology of husband and wife. It will keep us busy until eternity, and we won't resolve it. Evidence on affidavit. So we dealt a little bit with that. The court made any time a good cause shown order, then of course, or any of the evidence be given an affidavit instead of witness appearing at a trial to give oral evidence. They can do that. We spoke about it in the first 3 days. You can either give it on the papers, or you can give it via a walkie. Just remember one thing, ladies and gentlemen, I am lecturing on the High Court. This means the bench has discretion. Do you remember the first day? We said the lower courts is a creature of statute, and I called the High Court a creature of discretion, all right? So they can basically do anything as long as it's legal, and of course, basically, as long as it's constitutional. That's actually the big thing in South Africa nowadays. We're going on there on page 126, consolidation of actions, 1810. We did already talk a little bit about this, where you can put things together or keep them apart, or whatever the situation. We did touch on this. You would remember that was Rule 11. Where separate actions has been instituted and appears to the court convenient to do so, it may, upon the application of any party thereto, and after notice to all interested parties, make an order of consolidating such actions, whereupon the said action shall proceed as one. Most of the time, the court will not know. Most of the time, ladies and gentlemen, it will be you that brings an application, and many times the opposition will oppose it, because they don't want it. They don't want it for various reasons. Evidentiary reasons is a big one. They don't want this other guy in this court case, but it's actually the same. So, you're going to bring this usually under the court's attentions. It's very rarely that I've seen in my life that the court would know about this. So So yeah, have a look there at Rule 11. Rule 10 will apply in such a case with the necessary alteration and the court make any order which to it meet with regard to such further proceedings. And I'm going to tell you guys, you can go on and read that further in your own time. Just give me a second. Still fighting this bloody COVID. All right. Not to worry. We are out of our quarantine even before I started with this lecture. So the COVID germs can't go through the screen and latch onto you. Can't. It's impossible, according to me. All right, guys. I have a master's degree in medical law, so I think I'm right. All right, so don't worry about it. We're out of quarantine, but even if you're out of quarantine, you have no idea. That doesn't mean that it stops attacking you. All right, page 127, instructions to councils. Let's look at a brief there. Again, I've spoken so many times about this. The golden rule is to copy the whole file. It's true that attorneys don't do it, but it's also true that attorneys want some documentation to be kept away from their counsels. That you know that. That before attorney of record and his client consults with his counsel, they must actually decide on what they're going to say to the counsel. I had a case like that where an attorney almost in a boardroom had a heart attack. I was brought in to defend him. And as I was questioning, I always approached this very aggressively before I become nice, because I want the truth. And he almost admitted to something. And the attorney almost had a heart attack and asked me, stopped everything, asked me respectfully if I can just go and sit in the lobby. He needs to talk to his client. And when I came back, the guy didn't venture into a certain direction at all. I had my suspicions. He was definitely there, driven into a corner by me. So there's a lot of documents they don't want the counsel to have. And I know it sounds very strange what I'm teaching you now. So what I used to do, yes, a streetwise tip. What I used to do is I used to walk into a boardroom, sit down with the attorney of record, and I always brought this conduct rule under their attention. I would always say to the attorney of record, before we start, I'm the counsel here. Are we having an open consultation here? Have you spoken to your client? Have you informed your client that there are certain things that that you don't want him to bring under my attention? Have you gone through the conduct rule of that? A lot of attorneys rip their head off. They don't even know about it. But this one attorney, very good attorney, knew, and he almost had a heart attack, went out, came back, and I never knew what he was going to say. If he said it, if he uttered it to me, then I could not have defended him, for example, on plead not guilty or something like that. I'll have to fight it on a technical issue. This is difficult stuff I'm talking about now, very sensitive stuff. So I'm going to leave it there. Just bear in mind, between advocates and attorneys, there is a gap. So it's important that I bring that under your attention. Okay, let's look at it. Instructions to counsel. Golden rule is, as far as possible, give them the whole file. I always ask my attorneys of records, give me the whole file. So that's why I explained this other thing to you. Counsel's brief must contain at least the following: copies of all pleadings, copies of all statements, witness copies of all relevant documentation, copies of all expert notices and summaries, and so it goes. Copies of all relevant documentation discovered, copies of all relevant correspondence exchanged between different attorneys, blah, blah, blah. Mark that one for me, please, as important, ladies and gentlemen. Copies of all relevant correspondence exchanged between different attorneys. You write letters, and I have destroyed cases on letters written by attorneys. One of the cases about 2 years ago, also down in Cape Town, I was involved with for a couple of years, was a very arrogant chartered accountant wrote us a letter on information we requested from them. And the attorney sent the whole big 5-6 page letter to me saying, you know, he's now full of nonsense and saying this and he's saying that and that. And I read the letter and I went back to the attorney of record there in George and I said, hey, he's making admissions. And he is making contradictory statements to the opposing papers filed by the opposition in terms of who we sued. Attorney almost had a heart attack. She didn't see that. So showed her, look at that. And yeah, that's how you win cases. So be very careful how you write stuff. And another thing, here's another golden rule. Guys, write this down. Oh, yes, this is impossible. When you are in the first consultation with your client, you tell your client, especially in divorce cases, I am your attorney now. That's it. If your husband, you're going to divorce, contacts you, or if his attorney contacts you, you say nothing to them. If you receive bad WhatsApps and SMS or whatever the situation is, you don't reply to them. You forward it to me, and I'll go to the opposing attorney, and I will say, keep your client in line, or I'm going to start issuing interdicts. This is very important. I've seen clients litigate over their attorney's head. I have seen clients lose their shit with the husband or the wife on the other side and reply to WhatsApps and totally wreck the case that was salvageable. So this is what I want to bring under your attention. Take a strong hand with your clients and say, I'm your attorney now. Stay out of the fight. Everything that happens, everything you receive, you report to me. I will deal with it. Yes, you have no idea if you have an out-of-control client or an emotional client that cannot control themselves and they reback back. There's a lot of bad attorneys out there. They would say to the client, in the attorney's firm, in a consultation room, they would say to the client, okay, let's rattle her. Let's get something in writing, because that's what a WhatsApp message is. That data is in writing. It's going to get printed. It's going to go through what I taught you yesterday and the day before in terms of data, section 15. Do you remember the Electronics Act? And then they sit and I type messages to this woman or this other person in a divorce case saying bad things to them. And then for the next hour, they're up and down. And that opposing attorney is sitting right beside his client. And the moment he's got something he can use, he says, okay, let's stop. I can use that. Okay, guys. Now that's streetwise. So please take control of your client. And if you have an out-of-control client, maybe you must make a difficult decision. And then, of course, they go on there to tell you more things. I'm not going to talk about interpreters because I think I did speak to it on day one. We spoke about interpreters, and I still told you a story about a colleague of mine that says, that guy is talking nonsense now. You need to stop this. What a nice guy, eh? What a nice colleague, advocate colleague who was sitting beside me. He says, no, man, that's my culture. That's my language. This guy doesn't know what the hell he's doing. And yeah, I still remember saying to you that the bench wasn't very happy with that, which I find very confusing because the bench knew precisely what was going on. All right. There on page 127, it's 09:33. We'll break at 10. When we come back, we'll ask a couple of guys if they want to do a Rule 43. Michelle really came back with such a good one. I'd like to listen to two more. And yeah, Michelle, you did really well there. Thank you very much for that. I appreciate it. And then on page 127, the trial, attorney's duties. All right. Okay. Let's just not go too fast. Let's have a look at this. It is once again emphasized that it's the duty of the attorney. Guys, one day you're going to be the same as me. You're going to talk out of your head about this stuff. You're going to have 20, 30, 40 years behind you. It's not being clever. It's having experience. You've been through it, so you know it all. Well, you'll never know it all. But you're going to get there, and it's going to be fun. Yeah, sure, it's going to be up and down times. That happens and you get very upset. You get very upset if you lose a case because the adjudicator on the bench doesn't know what he's doing, you know, especially when you become senior and you know better. All right, the attorney's duties there is one again emphasized that it's the duty of the attorney to support the advocate in the conduct of the trial. I love it. I love my attorney beside me. I'm not better than him. I'm not better qualified than him. What nonsense is that? You know, I could never understand that even in the old days. That was not my take. I always used to say to my attorneys, we're going to do this together. We're a team. And if you see I'm making a mistake, don't be afraid to say, advocate, just tell me nicely, you know, obviously. But just tell me, advocate, I think, shouldn't it be like this? And one thing about me is I've learned myself as an advocate with this title, not to carry it on my shoulders, not to walk around with a chip on my shoulders. I very quickly say, oops, I was wrong, you're right. And that creates not only professional relationships, but long-lasting friendships. Because most advocates, unfortunately, have a chip on their shoulders. And I hate it. I hate it. So yes, I'm a team with my attorney. And sometimes when I'm in cross-examination, I'll see a little yellow note come under my arm. And I'll quickly read it while waiting for the person in the box to answer. And I'll nod or I'll bend down and quickly say, we'll do this a little bit later. Or no, I don't want to do it. I'll explain to you later. I'm an absolute team player in court. Because I tell you, if you and your attorney and your advocate work as a team together in court, and I'm talking about criminal cases and I'm talking about cases going on trial, not talking about a motion court, all of you are going to be making a lot of money there in the beginning because you're juniors. At a certain stage, I didn't want to go to the motion court anymore because you become a senior. So that's what I'm talking about. Absolute team player. What a fun. What fun. And you fight it together, you win it together, or you lose it together. And a last thing I want to say about this is, those of you that's going to become attorneys, don't just jump from advocate to advocate. You've given me a case now we lose it. Now suddenly I'm a shit advocate. There's no such thing. If I've done my work, you'll know it. And even if I've lost and I've done my work, you'll know it. Both lasting relationships between advocates and attorneys. All right, so they're also saying there, for this reason, an attorney, or at least his candidate attorney, ought to be present during the course of the whole trial. When you work with an advocate and you're not going to go personally to the court, and you're going to say the candidate attorney, be careful with that, let him know beforehand, or he'll think that is disrespectful, that you don't deem him important, the guy you've instructed to do the case. Just phone him and say, listen, I'm busy, it's urgent, I got to go here, but I'm sending a candidate attorney, so you can chase her around. Just handle that right. You have no idea. Some advocates, they really think they are way too special. Attorneys too, but I found it in the advocates profession to be actually a problem, where advocates have done something wrong and they will not submit. They'll argue with the attorney. No, that it wasn't their mistake and so on. That's such nonsense. So I'm teaching you something. If you've done something wrong and it's really wrong, then it's wrong. And you admit to it and you move it on. Most clients won't retaliate against you if you are open from the beginning. Shit, I made a mistake here. Yeah, I know, you don't want to do that, right? But I've learned as an advocate very quickly. No, I was wrong. You are right. Let's fix it. Okay, going on there on page 27, paging over to 28. Still a couple of things that I'm mentioning there. I want to go through this with you, so bear with me. The attorney should have a thorough knowledge of the facts of the case, the law involved, and the relevant rules of evidence and procedures. The golden rule in any court proceedings, that attorney must be fully prepared. All right. Very interesting statement. You won't believe it, how many attorneys of record that came to know me. After they came to know how I fight in court and how I do my work, I'll get a phone call. And they would say, especially with divorces, they would say, James, I've got 3 divorces here. Do you want them? I'll say, yeah, sure, I want them. In those days when I was a junior, I don't like doing those things anymore. And I'll arrive there at the offices. I like to go to the offices. Be careful of that. The rule of conduct actually has got an issue with that. Go read your conduct rules. They have issue with that. Where you meet advocates. Can you believe that? And in any event, I used to go out and meet the attorneys, but you must be careful under this new conduct rules. You have to go and read and study them. And I would arrive there, and the attorney would say, can you manage and run everything? I'll give you a mandate, a full mandate. You're in full control of these 3 divorces. So yeah, that is, I used to do that a lot because they trusted me. But I always used to write the email back and say to the attorney of record, I'm doing this. This is what's happening. Are you satisfied? And then I would say, hey, James, don't write us an email, man. You're wasting us time. We've got other shit to do. And I say, no. You are leaving this whole case in my hands as a counsel. I just want to cover myself. So that means they don't really have a knowledge of the case. The attorney of record. Now, that's unethical. That's unethical. Because at the end of the day, remember, I'm not getting paid by the client. I'm getting paid by the attorney of record. So be careful of that. I had the way to manage it ethically. You've got to be so careful. You've got to be so careful. So-called brilliant questions or clever arguments are never discovered or formulated in court. They are the result of preparation, and more preparation before a trial. One of my attorney of records one day in a criminal case asked me, why do you always send, before we go into the court, this 100 or 50 questions you're going to be asking to me? So that's how I do it. He says, yes, but you put a lot of effort into your work. I'll never do this. I walk into court and I gunfighter from the hip. And I always thought, what an idiot. How prepared are you? So I usually sit before the time. Sometimes I actually set up 150 questions. And then I have these questions on a cross-examination in front of me. And I would change as the answers are coming out. Then some questions become obviously non-relevant. And I had an attorney ask me, yes, that's really doing your work. I'll never do that. And I thought, yeah, I'll never work with you too, you idiot. Always understand the difference between a clever argument and a wise argument. Okay, yeah, you know. In broad terms, an attorney would conduct his client's case and put forth clever arguments. The judge, however, will dispense justice on the basis of wise argument, and it behoves, what a nice word, behoves, a practitioner to include wise argument in his presentation of the case to the court. Well, let me teach you something here, a little bit streetwise. Most of the time, you are a linker. You are a linker. What does that mean? That means that you take case precedent, cases that's already been decided, and you link them and argue from them. So that's, I call it linking. So most of the time, you walk into court, you say, my lord, I refer you to that case, so blah, 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 this case, blah, blah, blah. So you'll make a deduction and a final conclusion. So the argument is a lot of times not even your own. In criminal cases, well, you do the same, but a lot of times there it has to come from somewhere else. But in civil litigation, there's so much case precedent out there. So you can be wise the whole time riding on good court cases in your arguments. You must just do your work and your research. What orders may ought give at the end of the trial? Well, let's have a look at it. Judgment in favor of the plaintiff as framed or determined by the court. Dismiss the plaintiff's claim in total or as determined by the court. Grant absolution from the instance, and we taught you yesterday or the day before, I think, about absolution. And there you have the very well-known court case that you must have been taught at university level, the Carmichael versus Ministers case of 2001. Then the last thing they are saying, said there, dismiss the counterclaim. In the matter DC versus Rattan NO, Nomeo Officio, the court held that adjustment must be confined to issues raised by the parties. The court should not decide issues irrelevant to the outcome of the case. I've had it in many court cases where I have argued in front of the court. This is the situation, and the court would say to me, but that was not part of your submissions in your papers, especially if I didn't put the papers up myself. The attorney did it, and I've had that a lot. So I have seen judges, by the way, guys, I've seen judges go wide. But there you have a case in 2018, it's brand new, that actually sets down the rules, and I kind of agree with it. So I have decided. One judge actually said to me one day in court, he agrees with me that this is going to be an unfair ruling from his side, because what I'm saying is true, but it's not admissible because the attorneys, I think we were the third legal team on the case. So the guys that started out, that created a situation there. And he says he can see that what I'm asking for should happen, but he cannot order it because it's not in the papers. And I cannot submit it. I cannot argue on it in open court because it's not in the papers. So be careful. That's why I say now, I'm a lengthy drafter. I take my time. All right, that's it. Now we're going to what? Settlement offers and interim payments. We're on now 09:45. We'll take a break in 15 minutes, and hopefully when we come back, somebody would say I'm brave enough to do Rule 43. All right, settlement offers and interim payments. We have spoken about settlement offers. We have spoken about the negotiation period. We have spoken about the fact that you must lock it down, because if you can't reach a settlement, there must be a date that this negotiation is over so that we can come out of the situation without prejudice. And we have spoken about the fact that under prejudice, within the negotiation period, those documents cannot be part and parcel of discovery. Do you remember? So I'm not going to do a lot on that, but I am going to look at a draft. Look there on page 128, paragraph 20.2, I want to look at a draft because I did tell you this in the week, that the one thing that's very important is that you have to settle correctly. And unfortunately, the homework this afternoon is going to be to oppose the Rule 43. So I will not be able to test you on your parental agreement. But, Kutsia, I think Annerie is Kutsia. Annerie Kutsia, if I'm not mistaken. Is that correct, Annerie? Or you Kutsia? And she actually built the parental agreement into the opposing papers. So I'm actually happy that we had feedback on it because it's quite correct. And she did it in detail, and that's what a parental plan in any event is all about. So let's look at how they drafted it. Please take notice that in terms of the written authorization of the defendant, the amount of 50,000 rand is hereby offered together with the tax cost to date without prejudice to the defendant's right in full and final settlement of the plaintiff's claim. So let's just teach you a little bit about the drafting skill there. Have a look at that. Obviously, that's not your whole settlement agreement. Settlement agreements, if I put them up, they are rarely under 10 pages. But there is the way they put it up. Please take notice that in terms of written authorization, so they're making an offer. So that is not a settlement agreement, that's a settlement offer. So that's actually the paragraph that will be in your letter, long before you get to drafting the settlement agreement itself. And that's how they tender it. And please underline, without prejudice to the defendant's rights. Without prejudice to the defendant's right. That is what you have to underline. I very rarely see that people draft it into the settlement office because they rely on the law of non-prejudicial already existing that will protect them. And that is also true. But this is professional. This is professional, all right. Okay, guys, page 129, as we're going up to 10 o'clock. There we have an unconditional offer of settlement. That's great. If the offer is made unconditionally with regard to the party may accept it, the litigation comes to an end, obviously. Settlement offer without means that a party makes the offer denies liability. The offer is made only to try and settle the case out of court. Now, interesting enough, this is actually something that's very strange. A lot of people don't want to go to court, and they actually settle cases due to that. It's a weird thing, it happens. Especially in criminal cases. In criminal cases, people will make a mediocre deal because they don't want to go to court. And it's a big American thing. It's a big American thing. So it's actually interesting. It's just something I'm saying there in passing. The acceptance of the offer, the party to whom the offer or tender is made is entitled to accept it within 15 days after receipt of the notice. Therefore, this is when you're in official litigation. After 15 days, because then you're under the DIS. If you've written a letter of demand, people can reach a settlement. This 15 days won't apply. After 15 days have expired, the offer must be accepted only by the written consent of the party who made the offer. Please underline by written consent. Don't go into verbal nonsense. We don't live in that world anymore. The court may also, under certain circumstances, authorize the party to whom the offer or tender was made to accept it after 15 days have expired. So please have a look at that. And they have notes in there. The notes is important. I'm not going to go into them. You can read that in your own time. The aim of the offer made without prejudice is not only to bring litigation to an early end, but also to protect the party who makes the offer against costs should the opposite party not accept the offer, and a lower amount is subsequently granted by the court, and then at the end of the day, that can have cost implications. Should the offer not be accepted, the trial continues in the usual way. After judgment has been granted, the contents of the offer may be disclosed, and so the story goes. You can go and look at it. I just want to make a final statement here. Guys, be careful. Excuse me. If you draft a settlement offer, make certain you know what you're doing. What I usually do, you see this letter? Please take notice that in terms of the written authorization, that 50,000 letter on the paragraph 20.2 on the page 128. What I usually do is, that is the offer, and then they will accept it in writing. They will say, yes, it's good. I attach it. And I paste that offer into the settlement agreement in the preamble. Contract drafting. A couple of you have asked out about those webinars I'm doing. So I've told you, you can contact Merlin September in terms of that. So yes, there you are. There you are. It's not to say I'll do the course, but I've got some brilliant courses there from time to time, right through the year, from deceased estates, you name it. You name it. I get guys like me in there, and we talk to you 2 hours a day for 1 day, 2 days, or 3 days. The most I've done is 4 days, only 2 hours. And we teach you about so much. Shares in companies, that's so difficult, isn't it? So you can contact them and see what the dates is. There's not to say I'm going to do it, but you will benefit from it. So please, when you put up settlement agreements, do it right. I have seen settlement agreements that has been actually opposed later on, and the court says, well, that is not a settlement agreement. That contract can never be valid. All right, so that's that. Page 129. What about interim payments? Rule 54, capital A deals with that. In an action for damages for personal injuries or to the death of a person, the plaintiff may at any time after expiry of the period of the delivery of the notice of intention to defend apply to the court for an order directing the defendant to make an interim payment in respect of his claim for medical costs and loss of income, and so it goes. If the court is satisfied that the defendant has in writing admitted liability, blah, 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 the defendant is covered by insurance or has the means to enable him to pay. So those things there is very important, all right? So please have a look at that, and then you can apply that when you have to deal with interim payments. The procedure there is, in the supporting affidavit to such application, the following must be set out. The grounds for the application, the amount claimed. That's why I wanted you all to draft the Rule 43, so that you get into the habit of drafting an affidavit. And the Rule 43 is a good way of doing it. That's why if you haven't done it, it is really, really to your detriment. Because drafting of affidavits, it's more easier than a particulars of claim, but you need that that exercise. And something I draft a lot is criminal affidavits and criminal investigations. And if you draft that poorly, then you have the IO in your face, the investigating officer, and he calls you as an advocate or an attorney an idiot in your face. So you need that exercise. You absolutely need it, or you're going to do it wrong. And then they say, on a documented proof of liable allegation that the opposite party admitted liability in writing, or the plaintiff has obtained judgments against the respondent for damage to be determined. So you must attach that. A copy of the written admission of ability of court order must also be attached to the affidavit. So that is then the instances, and they take it a little bit further there. Right, we talk about hints of drafting. Let's see what they are trying to say to us here. Attorneys must particularly careful regarding to settling matters if the client is not present or doesn't sign. Oh, boys, yeah, let me talk about this. Don't you sign a settlement agreement on behalf of your client in England if he has not approved it. If you take a power of attorney to that extent, I actually want to tell you, you shouldn't do it. But unfortunately, it's legal. You can do it. But this is so freaking dangerous. I know about an attorney who once told me a story. He had this very big client in America, and they went into a settle agreement, and it's a South African, but he's residing in America. And he said to this attorney, you have power of attorney, sign it, everything. And then when it was signed on his behalf, he wasn't available. I don't know if he was on vacation on the bush or somewhere there in America. He was not satisfied with it, and he got on the phone and he verbally abused this attorney, and then he refused to pay this attorney's account. There was such an unpleasantness. This attorney was so upset. He said to me, he's never getting into civil litigation again. So I actually had to calm him down, because he made a lot of money out of civil litigation. I didn't agree always with his tactics. He was too lengthy, never could make a final decision. But so I want to say to you, please, guys, be so careful to get into this nonsense. I don't want you to do this. I don't want you to do this, except if in the power of attorney, now make notes here, except if in the power of attorney, you agree to minimum requirements, would the settlement become prevalent. What do I mean? He will go into the power of attorney, says, well, if I'm not available, you can go ahead, you can settle on my behalf, but this is the minimum requirements. I will not take less than 20,000 Rand. I want the costs to be dealt with like this and this. All of those things. If you can put up a power of attorney that's inclusive of the minimum requirements, I might kind of say, okay, try it. I have never in my whole career done this. I deem it too dangerous. Too many instances occur where a client expresses gratitude when a matter is settled, thereby possibly obviating a court appearance, only to have the gratitude replaced with anger and recrimination when he/she is called upon to pay in terms of the settlement. There you have it. So have a look at that. I'm not going to take it further. I think I've said enough, and it seems that the guide is in agreement with me. All right, guys, amendments to pleadings and documents. We've got 4 minutes to go there. Let me just page and see how far that's going to go. All right, we can talk about it. It's down into sub-paragraphs. Let's quickly do on page 151, the general one there. A variety of reasons may exist why pleadings or documents must be amended. The amount claimed in the summons is wrong, or a material allegation in the plea is omitted. So yeah, that happens a lot. That's why I've said to you, please guys, I've got the 8th edition of Harm's LexisNexis. He's the publisher. I'm the Presidents of Pleadings. Consulted. I have found that they, in 99.99%, their pleadings are quite all right. So always work out of that for your action procedures and make certain that you don't make mistakes. I've had to do in my career many amendments, unbelievably a lot of amendments. And when we go to application procedures, I'm just going to talk out of the fist about this. Of course, then you won't use things like supporting or confirming affidavits. You will use what? Supplementary affidavits. Supplementary affidavits to bring an amendment by due to a supplementary affidavit. And if you look there in the guide, I see they are saying to you to do it by a supplementary affidavit. So please make a note there. I see a lot of people make this mistake. Seasoned attorneys and advocates make this mistake. They don't know the difference between a supplementary affidavit, the confirming affidavit, and a supporting affidavit. Now, out of the first, I'm going to quickly explain it quickly to you. Supplementary affidavit is supplementing the founding affidavit, like amendments or extra information that wasn't there, and you want to bring it under the courts against it. That's supplementary affidavit. Confirming affidavit is usually affidavit confirming content. You get it a lot where it's a man and a husband, and the man is making the statement, she's confirming it, and confirming the content. I hereby confirm the content as far as it pertains to me. Confirming affidavit. Supporting affidavit is not a confirming affidavit. Supporting affidavit is more like a witness, and he brings something new to the whole situation apart from what's in the founding affidavit. That's the way I've been using it for years. Other guys may use it in another manner, but obviously you have to go and look at the differences there. And I've seen guys muck this up thoroughly, especially with the supplementary affidavit. They would call something that's a confirmatory affidavit or a supporting affidavit. They'll call a supplementary affidavit in their railway lines. And that's totally 100% wrong. Okay, let's just finish this 21.1 general and we can break for 15 minutes. And when I come back, I need 2 volunteers, guys. So please, I'm going to call 2 volunteers out. Hopefully there's 2 people that will give us feedback on Rule 43. Pleadings include the following: a simple summons, a declaration. And when you hear the word declaration now, for the rest of your life, you will know simple summons. A combined summons, a plea, a claim and reconvention, request for further particulars for purpose of trial, and the answer to that, the replication, a rejoinder, and other pleadings referred to above. Documents include annexes to the pleadings and notices. With regard to notices, it also includes the annexes, a summary of an expert's opinion, and his reasons for it. So there you have it. Up to 10 o'clock, 15 minutes break. I'll see you. I'll come back and I'll see you in 15. Hopefully Janet, JM, will also ask Janet. Janet, maybe you've done your Rule 43, so we'll come back. We'll ask you if you have done it. Okay, I'll see you guys in 15. All right, guys, we're back, and we're going to go on with amendments to pleadings and documents. Is there anybody that wants to give feedback on the Rule 43? Janet, I saw your name. Janet, have you done your Rule 43? JM, anybody wants to give feedback? Otherwise, I'm going to go on. Luckily, we had one person that gave feedback and it was done well, so everybody who listened, I suppose. Anybody raising their hand? Nobody? All right, let's go on. I'm not going to waste time. We still have to go quite a while this afternoon to get to where we need to get. All right, guys, so that was the general introduction to amendments. Let's quickly have a look there at the procedure. Any party desiring to amend any pleading or documents on page 151, paragraph 21.2. Any party desiring to amend any pleading or documents shall give notice to the other parties. You've got a proposed amendment is made within 10 days. Within 10 days of the expiration of the period for objection, because the people can object to it, especially if it's going to be prejudicial. Because sometimes you've mucked up your case so badly, you cannot actually make amendments. Failure to adhere to the time periods may result in the amendment failing as not being properly effected. So that is a whole official application you have to bring there. On page 152, they teach you more about it. If the objection is made within the set period, which objection must clearly be and concisely state the grounds on which it is founded. The party wishing to amend them, there could be problems. I'm not going to talk further about that. At the end of the day, it's all about the fact whether it's going to be prejudicial or not prejudicial. And it's all going to, and of course, now you won't be able to make an amendment that will add a new course of action. So all of those things we've been talking about from Monday to yesterday now are kind of become important. This now kind of become important. When an amendment to a pleading has been delivered, the other party shall be entitled to plead to and amend consequential and plead. Okay, so it's the same thing. You've now amended the particulars of claim, but our other party obviously now can plead to it. Just like they've plead to your original POC, which you now amended. And then, of course, there is time periods, 15 days, and all of those things are also important there. Amendments may also be effected to pleadings or documents at the commencement of or during the trial. And the general principle is that a party desiring to amending his pleading or document must give notice thereof as early as possible to the opposite party. Such an amendment be requested shortly before or during the trial, and such amendment is prejudicial, underline that, and such amendment is prejudicial to the opposite party in the conduct of his case. The court may grant a postponement on request of the opposite party and the party desiring the amendment to pay the wasted costs. So that's stuff that's important. All right, and then there at the end, they say amendments will normally be allowed unless the application is mala fide, underline that, or would cause an injustice to the other side, which cannot be cured by an order as to cost, and where appropriate, a postponement. And they are talking there about prejudice. If that amendment is made, it will be prejudicial to your case. That happens quite a lot, and that's quite one of the biggest reasons that amendments actually cannot be made, because they have set up the POC in such a manner that to now amend it would be prejudicial to your client. An amendment that will introduce a new course of action may, in principle, be allowed. So I don't know, I had a lot of judges that bombed that out, so be careful with that. You cannot introduce a new course of action. That's actually one of the rules there. But they say here that in principle it can be allowed. Just right there, be cautious with this. An amendment that contains the withdrawal of an admission will only be allowed by a court if such admission is made in error. That's the prejudice. The affidavit supporting such an application to amend must contain evidence of the circumstances under which the admissions was made in error. So those are important things. Please be very careful with adding a new course of action. A lot of judges throws that actually literally out of court. So be careful with that. In my career, I must admit, in my whole career, I've never, ever added a new course of action. All right, on page 133, we are going on there. We're still busy with the same. Where a proposed amendment is bad in law and expediable, the court will not grant an amendment. That's logical. In Joel's Eiendom in another 2007, it was held that although the Court of Appeal was in principle empowered to grant an amendment of the pleadings, this power would be sparingly exercised, and an amendment would only be allowed in cases where the court was satisfied that the other side would not be prejudiced hereby. And I think we've said that a million times. So be careful with that. Sometimes to add another cause of action can also be prejudicial in terms of how you have set up your papers. And that is also one of the reasons why that can then not be done. Care should be taken when applying for amendment, which would introduce a new causa, that you do not encounter prescription problems. That's another reason. Prescription in regard to amended causa would run until the day that the court grants the amendment, if the court granted the amendment, and the prior service of the summons based on the old causa would not interrupt prescription of the new causa. So those things are very important. Please take cognizance thereof. Moving on to interlocutory applications. Now, in short, what is an interlocutory application? You have your main case, and suddenly something happens, and basically you have to step aside out of your main case to argue this before you can proceed with your main case. All right, so that starts on page 154. Let's have a look at it. It must be kept in mind that the court case often consists not only of a single trial, but that all kinds of applications may be brought in the course of the litigation between the parties to give effect to the rules discussed above. For that matter, interlocutory relief may be asked for a course of a case from the issuing of the summons to the final hearing of the case. The term interlocutory refers to an application which arises between the beginning and the end of a lawsuit or proceeding to either decide a particular point or matter that is not the final issue of entire controversy or prevent irreparable harm during the pendency of the lawsuit. And Rule 611 deals with it there, and they say there, applications incidental to pending proceedings. An application is incidental to pending proceedings if it is subordinate or accessory to, while at the same time being distinct from the main proceedings. And so those are the interlocutory applications you can get. You're running that main case, and something happens, and then they do this. Interlocutory applications are brought on notice supported by such affidavits as the case may require, and are set down at a time assigned by the registrar or as directed by the judge. Interlocutory and other applications incidental to pending proceedings need not be served by the sheriff, because everybody is in court, everybody knows about it, it's happening in real time. Service may be affected upon the attorney of record of the respondent party initiating the proceedings. The provision of the rules relating to the time for filing, answering, and replying affidavits do not apply to interlocutory applications. Further affidavits in interlocutory applications must be filed within a reasonable time, prima facie in the absence of special circumstances. This would not be longer than a time prescribed in terms of rule so-and-so. All right, so they say the examples of interlocutory applications include applications to compel discovery, applications to compel a reply to a request for further particulars, and applications for maintenance pendente lighting. So those, ladies and gentlemen, are some of the interlocutory applications in civil litigation. I actually think that I know that in the criminal court, I also call it interlocutory applications. In criminal litigation, a lot of people will differ from me, but I like to call it interlocutory applications. In criminal procedure, one of the ones I've done the most is the adjudicator is biased. The adjudicator is biased. In one of my big cases recently, the state advocate brought an application and said that the bench favored the defense, which was not the truth. And again, I had Colin the Val with me, the rights handbook, and that actually was the reason I could stand that application off. We were ordered by the bench to take half an hour. We went down to I think it was Kentucky or the Wimpy. We sat there and I quickly formulated an argument out of the Val and Curry. Came back, argued for about an hour and a half, my side, state side. And at the end of the day, it was ruled in our favor. So yeah, these things happened. I call it the interlocutory application within a criminal case, but there is another name for it. I just like to call it that because that's actually what it is. The whole main case gets set aside for a moment and something else is quickly argued. All right, security for costs. You will get us a lot. in your civil litigation career. Okay, so we're going to talk about that a little bit. What do the rules stipulate about this? And you will be looking at Rule 47 sub 1. The party entitled and desiring to mine security for cost from another shall, as soon as practicable after the commencement of the proceedings, deliver a notice setting forth the grounds upon which such security is claimed, excuse me, and the amount demanded. A substantial delay in applying for security may warrant a refusal thereof by the court, and that is the one I want you to mark. Mark that, that if you wait too long, most probably you won't be able to do that. If an amount of security is contested, the register shall determine the amount. If the party refuses to furnish security, the other party may apply to court on notice for an order that such security be given and that the proceedings be stayed until such order is complied with. So underline that. That is what I usually do. They bring an application and say, well, this court case is not going further until we have that security in place. The following could act as a guideline for the usual order requested by the applicant. The respondent is directed, so you're drafting now. This is practical drafting. So you can make a note there. This is practical drafting. This is the wording you'll use. The respondent is directed to furnish the applicant with security for cost in an amount to be determined by the register. The respondent's claim on the case number so-and-so is stayed until such time as the respondent has furnished the enforced security for cost. So if you ever want to do it, you use this wording. The applicant is granted leave to approach this court on the same papers, duly supplemented when necessary to seek a dismissal of the respondent's claim with costs. In the event that the respondent does not furnish the security within 30 days of the register determining the quantum of that security, that the respondent pays the cost of the application. Now, in the second one, you must be careful. They're actually saying, yeah, well, you started the case. So if you don't provide security, then we're going to go for a cost order up to that point against you. So the second one is kind of more severe than the first one, if you can read it and appreciate it. All right, so that's important there. In an application for security for costs against a company plaintiff, the discretion to order such request vests in the court. That's always the case. And such discretion is to be exercised with due regard to the right of access to court under 34 of the Constitution. Now, there it is, Section 34. Do you remember in the week? We showed there that a person going for personal interest approached the courts on behalf of a class of people, on behalf of associations, do you remember? And I still say to you, I think that that section in the Constitution is somewhere there in the 50s. So there it is, underline it. You see, in the beginning of your guide, who can approach a court is Section 34. And this is now what I want to talk about. One of the arguments you can counter with is then, of course, the constitutional right to access of court. And if somebody is enforcing a security upon you, you can actually go into Karen de Waal. They've got a lot of court cases there talking about your right to access of court. And that's a fundamental, comparative, and constitutional right that everybody has. So that's the counter argument I will bring. One of the counter arguments I will bring when somebody is trying to force me to put down a security and to stay the case. So that is what I will go for. I like to bring constitutional arguments. I actually enjoy it. It's a subject that I'm well familiar with. So that's it. And then, of course, if you go to page 136, you'll see there potential injustice. Potential injustice. That is the take you will do on this. And of course, there you have it, 2007 Constitutional Court Case of Barnard, where they actually dealt with it. The probability that a company would be unable to meet an adverse cost order did not justify the inference that it would be unable to furnish security, as these were different issues. There you see it in 2007 MTN service provider case. And there they said, get out of court. It's not a good enough argument to enforce security. And so it's like summary judgment. It's like summary judgment. It's kind of unconstitutional. You must be very careful. So you can counter this. You can oppose it and you can successfully get rid of it. But it is granted. It is granted. And sometimes, or most of the times, it's granted by consent. By consent. Where the parties actually agree to it. So yeah, that's what that's all about. All right, when may security for cost be demanded? Okay, obviously, a peregrine. Where a plaintiff, applicant, or other conventional reconvenes a peregrinus of the Republic and does not own unmortgaged immovable property in the Republic, the defendant or respondent is entitled to demand security for cost
for action from the plaintiff or applicant. So in the terms of peregrinus, there you have a good example there. Actions by a company or close corporation, Section 30 of the Companies Act makes provision for a defendant to request a company or a close to provide security for cost if there was reason to believe that a company or its liquidator would be unable to pay the cost of the defense upon the successful. So that's the other reason. And then, of course, if you talk about peregrini, you're also going to talk about in cola. So at common law, an in cola company could not give security for cost of proceeding. There was no exception to this rule. In Haitis versus Portwell Groups 2011, so we satisfied the court relying on, in its inherent power to regulate it on process and the development, the common law, and taking into account the interest of justice, held that courts should not hesitate to order such a party to file security for cost, stressing, however, that each case should be decided on its own facts. And that was in 2011. It is still the same case that runs in 2007. In terms of MTN services, 2007, the Barnard case, and they actually reiterate those cases because they say it must be decided on its own facts. In Eugenia Gold versus Precious Prospect of 2011, Van der Merwe judge disagreed with his case and dismissed the application for cost. And I kind of agree with that. I'm going with what happened in Eugenia Gold because that is how I would then approach it myself. So, ladies and gentlemen, in terms of security of cost, understand it correctly, it can be unconstitutional, specifically in terms of your right to access to court. So they're really going to have to prove that you're bankrupt or there's really something going on. In terms of the peregrini, I agree. Don't get me wrong. In terms of the peregrini, I agree. Obviously, that's logical. You never know where people's going to run to, and there's nothing you can attach. Remember what we said in the beginning, What did we say in the beginning? We can also establish jurisdiction by what? By attaching property. That's something you can use also here in terms of security. So there's a couple of things you can link up with each other to make this happen. All right. So the matter, so there I go on page 157. They talk about for analysis of uncertain positions. See van Lochenberg. He talks there about Section 13 of the previous acts was probable the result of an oversight on the part of the legislature, which contention is strengthened by the fact that the legislature left Section 8 of the Close Corporation Act intact and unaffected in framing the new act, and that legislative intervention was necessary to rectify the situation. So please have a look at that. The matter has now been determined in the Supreme Court of Appeal in the Boost case of 2015, which is brand new. Both companies and close corporation can, given the relevant circumstances, be ordered to provide security. Of course, the argument is prevalent. The argument can be blocked by a well-formulated constitutional argument. Okay, let's have a look at it then. Action by insolvent. An insolvent who acts as plaintiff on an applicant may be ordered to furnish the security for cost of the action. I'm not even going to talk about it further. It's common sense, insolvent. That's your key word. Vexatious or reckless. This occurs when there's an abuse of the court process. Examples would be where the action is obviously unsustainable or where the proceedings are employed for ulterior purposes. This happens a lot. When attorneys and the clients start to play games on a vexatious and reckless foundations, let's get them from all sides. Let's make a lot of things happen, even though we know they won't stick. So the moment you can determine that, you'll bring an application, you will attach all of that. And then, of course, then the security can also be issued. In most of these instances, you'll see that a case is removed from the roll if it is opposed in the right manner. What happens if the security is not given? Okay, the court may, if security is not given within a reasonable time, dismiss any proceedings instituted, to strike out any pleadings filed by the party in default, or make such an order, or make such other order is complied with in Rule 47 sub 3. We know the court has discretion, so they can move in all of those directions. Rule 47A, a person to whom legal aid is rendered by the legal board is not compelled to give security for the cost of the opposing party unless the court directs otherwise. So make a note there. I've done a couple of cases for the legal aid board. I was on the system, but I don't like working for them. But if you are starting out and you're a brand new legal practitioner, it might serve you well to get into their panel and take instructions from them. But I quickly found out that payment is bad, and usually it's an argument and all of that. I was actually one of the political advocates in political cases. So yeah, that's something you can approach the legal aid board if you are a newcomer to practice, and you can actually make money, because in the beginning you have to take what you can, and as you are successful and you're getting to be known, your fees will increase with your seniority, and you will be able to make a living. All right, there on page 158, an example of the possible wording of a notice in terms of Rule 47 is the following. So we're still busy with security. So this is drafting. Mark this important, because this is what you will do when you file such a notice. Kindly take notice that the respondent hereby demands security for costs from the applicant in the amount of 250,000 rand. Take notice further. Excuse me, that was just a sneeze. Take notice further that the amount of 250,000 rand is a reasonable estimate of the cost which the respondent would incur, and for which the applicant would be liable should the above honourable court rule in favour of the respondent and award cost in favour of the respondent. I like doing it like this, because they're kind of guiding the register here. They don't leaving the amount open for the register's discretion. Take notice further that the respondent is entitled to request security for costs on the basis that, inter alia, here you will set out the grounds for a request for security, insolvency, vexatious, malicious, peregrinus, or whatever the situation is there. That's what that's all about. But I like this notice, because when you leave it up to the register, he might actually give an amount which is quite ridiculous. So here in this notice, he's actually being guided. It's not to say that you'll get at 250,000 rand. Excuse me for a second. So today we don't have the problem of coughing. We have the problem of a runny nose. All right. Okay, that's that. That's finishing up with security of costs. And that's good. That's good. That explains it actually very well. And I like the idea of the practical examples, because that helps you as a newcomer to this fraternity, or this profession rather, that you can actually go back to this guide, keep this guide handy, and you can use it wherever you need it. All right. Now you would remember, there's actually basically two summons, isn't there? Your simple summons, your combined summons. You would recall that in the beginning of the week we said, well, you get your provincial centre summons also. Now let's have a look at it. So there's actually three, although your more common ones. If you ask anybody on the block, they'll say there's two, simple and combined. But indeed, we have seen that this is also a summons, and that is correct in any event. On page 138, provisional sentence is a hybrid procedure containing elements of both action and motion procedure. Now, motion procedure, I actually want you to write in brackets there beside motion procedure application. Because motion procedure in a motion court, I mean, you bring your actions into motion court also a lot of the times before they run into trial. So please be careful with that. Just put it in brackets, application procedure. I don't like to cap it down to motion procedure. It is instituted by way of summons, but adjudicated on affidavits. So there you have it. So if we put in brackets the word application procedure there, we're actually doing it right. So I rather want you to do that. The summons must allege all facts necessary to found the course of action, and the defendant must be informed of the consequences of the failure to pay the amount claimed, and the right to demand security for the restitution thereof if the amount is paid. Strange enough, in my career, I find it actually very strange. We did a lot of summary judgments, default judgments and so on, but provisional sentence, not so much, strange enough. The summons must not contain the underlying facts, and a causa must be drafted and based on the causa arising from the bill of exchange. Now, please underline bill of exchange. Underline bill of exchange. That means it can be a check, a promissory note, anything like that, and it amounts to a liquidated amount. Please just write it down. It's a liquidated document. Otherwise, you're not going to be able to do it. All right, so that's important for me. Why did I say checks? A lot of you are saying, this advocate is an idiot. From the beginning of the year, checks are out. No, checks are out, but not litigation on checks. Remember that the prescription period for bill of exchanges, checks, promissory notes, you call them out, are 6 years, not 3 years. So if the last check was legally written here in December, January, then you can still in the next 6 years litigate on that check. Did you know that? So yeah, vindicated myself with that statement. So checks can still be the course of action in a criminal case or a civil litigation, because they only prescribe after 6 years, and so please take that into regard. So from the beginning of December, January this year, still 6 years before you can actually not issue any proceedings on in civil litigations on checks. There's no prescription in criminal litigation. If they've committed fraud like 20 years ago and you find out now, they can actually be up for criminal charges. That's different. All right. When is this procedure used? Well, it's a special form of summons. You do it under Form 3, so they give it to you. You don't have to worry about working it out yourself. It's only used where the course of action is based on a liquid document. And that's why they say bill of exchange. Bill of exchange. Now, they talk a lot there about that under the Prescription Act. If I'm not mistaken, there's a Bill of Exchange Act too. A liquidated document may generally be defined as a written instrument signed by the defendant or his agent, evidencing an unconditional acknowledgement of indebtedness in a fixed sum of money. Underline fixed sum of money, that is a liquidated demand, a liquidated document, a liquidated claim. So there you are. I'm not going to even, well, okay, maybe we should just read that third paragraph. Do not confuse the concept liquid document with the concept liquidated claim. A liquidated claim is a claim for something specific, ejectment or delivery of payment of 100,000 rand. Okay, this paragraph is now so confusing. Please underline liquidated claim and payment for 150,000 rand. All right. So the paragraph is confusing. It's like it is not included in the concept of a liquidated claim. Of course it is. But specifically on the third one, payment of 150,000 rand. So please don't confuse that. That whole paragraph is actually out of proportion. It does not amount to ejectment or delivery, but if that 150,000 rand claim is based on a liquid document, yes. I'm not talking about damages, because a claim for damage is usually not liquidated claim. But if that 150,000 rand is based on, and actually, I don't know why this paragraph is in this book set out in this manner, because we actually explained this whole concept of a liquidated claim document during the week. I'm actually going to ask the drafter to just rephrase that. That's confusing. All right, we're going on examples of documents that may be liquidated documents, acknowledgement of debt, negotiable instrument will be a bill of exchange, a promissory note, or a check. Judgments, obviously, you can have a look at it there. And then mortgage bonds on page 140 and deeds of sale, page 140. And that is the situation there. Well, great, guys. That's fabulous. That's about the size of that. And then, of course, they actually go further. They talk about the architect certificate. I'm also always very impressed with this, because for a long period of time, I didn't know that the architect certificate is a liquidated document. Lease agreement, yeah, sure, we know that. We litigated more than enough on that. And those are the examples. They're self-explanatory, and you can also go then there. You can go and read on it, and there's a couple of court cases that's also been builded in there for you. All right, so let's move on. What does the summons look like then, if you draft it? And this is where this guide is very good, because it actually gives you the way it should be done and how it should look. And it teaches you that legal jargon I spoke a lot about Monday and Tuesday, I think. Okay, so we're on page 141. How should it look? Rule 8.1 provides the example. The wording of the instruction in the form here set out the course of action could read as follows. Amount together with interest thereon at a rate of per annum a tempora morae claimed by the plaintiff as being an amount due and payable by defendant to plaintiff by virtue of check dated, drawn by the defendant on so-and-so bank address in favor of the plaintiff and of which check plaintiff is the holder. So check is correct, because I told you of the 6 years. The said check was duly presented for payment at a bank of aforesaid, which same was dishonored by non-payment as a result of a lack of funds in the account of defendant at a said bank, the said check remains unpaid and is in a plaintiff possession. A copy of the said check is annexed here to mark so-and-so. So if you go back to the examples, it could, and you take the words check, all right? And of course, you'll have to get rid of the bank, but you could do this with acknowledgement of debt. A negotiable instrument is then, of course, a check, a promissory note, and a bill of exchange. You could have dealt with the judgment. You would have referred to a court order. You can deal with the mortgage bond, the deed of sale, the architect certificates, and the lease agreement as the examples they gave to you there. So you just have to apply the facts then. Obviously, when you're going to deal with acknowledgement of debt, for example, most probably you will not refer to the banks and so on. So you just amend it. You just pull it in shape and you use the correct terminology there. All right, and then also take note, checks has become something of the past now. Just right there, as from the beginning of 2021, it can still be litigated upon for 6 years, and under criminal litigation, well, that's unrestricted. A crime is a crime. All right, so yeah, they go on there, and they talk about it must be emphasized that Rule 8 sub 3 provides that copies of all documents upon which the claim is founded shall be annexed to the summons. That's true. A photocopy of the liquid document must be attached to the summons. We're happy with that. And if the defendant is within the jurisdiction of the court, a minimum period of 10 court days must expire for the date in which the summons was served. And so they talk about all of that, and you can go through that in your own time. All right, guys, then on page 142, they talk about issuing and serving. Let's just go to the top there. We have said this before, less than 150 kilometers, 14 days, more than 150 kilometers, 21 days. In terms of what? Calendar days must expire depending on the distance between a courthouse and the place where service is to be effected. So please just have a look at that. Issuing and serving, the provincial sentence summons is issued by the registrar and served by the sheriff, and the rates related to issue and service of the simple combined summons applies. Enrollment, unopposed actions. After the D Sch has expired, the matter must be set down for hearing before 12 AM on the court day, but one preceding the day upon which the provincial sentence application is to be heard. Provincial sentence applications are heard together with the ordinary applications, so that's not going to be a problem there. And for an example of the notice set out, see example 16. All right, guys. Let's go back to your examples. Let's go there, 13. I just want to see, the other day it worked 15. We are looking for what? 16. Let me just see there, if indeed they have done that for you. Okay, summons was served, this expired, defendant. All right, guys, you can go to page, Rule 8. You can go to page 223, and you'll see there, used for applications for summary judgment, judgment by default, and provincial sentence summons. On page 223, example 16, gives you the method in which it should be done then. So we're happy with that. It's in your book. All right. Enrollment, unopposed claims. We dealt with that. Okay, checklist. Let's look at a checklist. What do we need here? A copy of the provincial sentence summons, a copy of the return of service is going to be important. The original legal document where a mortgage bond is relied upon, original bond does not have to be handed in. It is too precious a document to be filed in court. Well, you know, always use copies or always use certified copies, but make certain that when you are in court that you have the original with you. That's what I recommend in the High Court. The notice of set down, which at the same time constitutes the draft order, at the hearing of the application, counsel will usually ask for an order in terms of prayers 1, 2, and 3 of the notice of set down. And so that's what that's all about. And please keep the original rather in your office. Make certified copies when you do these cases as far as possible, so that the originals cannot get lost. Opposed actions, but okay, let me just qualify that. Consult your legal practice, your practice directive of the court in which you are deployed, in which you operate. Just make certain that they don't, because I know for a long time in the magistrates court, they wanted the original to be issued on the court file at the very least, and that created problems because they got stolen. Opposed actions, the defendant personally or his legal representative on his behalf may appear in court and raise his defense. So that's something there. Just remember that, yeah, that's fine. I'm not going to talk about that. That's easy enough. The defendant may file on page 143 an answering affidavit that is notified to do in the summons. It calls for it. Remember, you bring the provincial sentence summons the same as the simple and combined summons, ordinary motion work, so you can do it in that manner. When such an affidavit is filed, the plaintiff is permitted to file a replying affidavit. Only 2 sets of affidavits usually be involved, although the court does have discretion to permit the filing of a further affidavit if good cause is shown. And this is what I was trying to say to you in the week. You cannot just go on filing affidavits and pleadings. And here they actually cite under provincial sentencing. It's the same with the other things. The moment you go actually past your third round of pleadings, then you need the leave of the court to do that. So there's something, and there we actually have it. I'm actually happy it's in the guide, because a lot of the delegates listening to me, they trust the guide. So what a guy is saying cannot always be right. So there you have it. The defendant may take points in limine, for instance, in limine, in limine, you decide what you want to call it. Everybody has his own pronunciation of that. On, for instance, the ground that a summons does not comply with the rule, the defendant may attack the liquid document by, for instance, alleging that it's not he or agent's signature that appears on the document. I've had that in the past. He may allege that a document is not liquid. That's the big one. Underline that one. A lot of people bring these applications on documents that's really not liquidated documents. So be careful with that. And that is where the confusion can come in with the liquidated claim. All right, so now we can link up. Maybe that's what I was trying to say with that paragraph. So you can go through there in your own time, read up on it. Provincial sentence summons, like I said, I haven't done a lot of them, couple here and there, but we basically, it's either default judgment or summary judgment, or we're in court and the court will render judgment. Enrollment of the opposed claim for provisional sentence. The applications are set down in the manner in which opposed applications are usually set down. However, the precise procedure may vary between divisions. Write there down. Right there behind the word divisions, practice directive. Practice directive, so that you know what I mean here. So all you do. By the way, a lot of the times the court would issue its practice directives. The specific practice directive may apply to a specific issue that they want to be dealt with in a specific manner. And sometimes some of the courts will actually keep on bringing that out in book form, where those practice directives are actually very bulky. So you must always just go to your court. You can go to the registrar if you cannot find it online. You must always say to him, can I have a copy of the newest practice directive? And they have to actually give it to you, because how else are you going to know, especially with eviction applications? That's so important to state that, yeah, that should be done, because every jurisdiction has got their own way of doing it. Checklist for counsel brief, that's for guys like me. Copy of the summons together with the documents in which the claim rests, copy of the return of service, and then, of course, you will give to me the original liquid document. A copy of the defense's answering affidavit, a copy of the plaintiff's affidavit, and a copy of the notice of set down. What is the position with regard to the onus of proof in the case of an opposed claim for provisional sentence? Should the defendant deny the liquidity of the document, the authenticity of the signature, or the authority of his agent, the onus of the proofs will obviously rest on the plaintiff when that becomes a defense. Should the defendant rely on the underlying defense on the merits, the onus of proof will rest on the defendant. So you must have a look at this. If they raise, no, that's not my signature, that thing is a false document, then the onus is on the plaintiff. But if it's something else, then the onus is on the merits, the onus of the proof rests on the defendant. And that's very important, because you have to argue that in court. You know, I don't want to say this, but a lot of people on the bench don't know what they're doing. And so you have to walk into court and you have to be ready at the end with these arguments to show the court what's going on. Not in a rude or obnoxious manner. But what I've done a lot in judges is, with judges is I actually, my closing arguments are sometimes very long, because I show them out of the law and out of the case precedent actually what they may or may not do. There is a problems with experience on your bench, in the High Court too, unfortunately. So you have to be thorough in your closing arguments. And this is one of the things you're going to say to the court. You're going to have to say to the court, well, in this case, the opposition raised this defense, and if they raise this defense, then the onus was on us. We have completed that, or the onus rests on them, and they didn't do well with that. So you're going to be on your feet before you walk into court. You're going to understand that you should also assist the bench in how the law operates, because I can tell you what a bench does is they postpone your case for such a long time before they come out with a judgment. But if you do your closing arguments in the right manner, a lot of the judges are just too happy to get rid of the case totally. I tell you, I've waited, in one case I waited 2 years for a ruling, and then the female judge in Johannesburg, wrote it out with a hand and couldn't even almost read it, things like that. So if you assist the bench with your closing arguments, it is better for you and your client. Okay, so in this provincial summons, whatever the situation is, what orders can the court make? Adjourn the proceedings on good cause shown, give final judgment. Grant provisional sentence where the plaintiff discharge his onus of proof will rest on the defendant. The court may refuse provisional sentence. In such a case, the defendant is usually ordered to file a plea with a stated time. The court may make a suitable order as to cause because it can go on trial. The effect of a provisional sentence is that the defendant may only enter into the principal case if he has satisfied the amount of the judgment and tax cost, or if the plaintiff on demand fails to furnish security in terms of 8.9, and of course you can read 8.10 there too. So those are the things you have to look at. The plaintiff shall on demand furnish the defendant with security, the rest to endo, to the satisfaction of the register against payment of the amount due on the judgment. The defendant must deliver a notice of his intention to enter into a principal case within 2 months, underline that, of the granting of the provincial sentence. Should he fail to do this, the provincial sentence automatically becomes a final after 2 months. And there's a lot of people that don't know that the period is 2 months here, so please mark that as important. All right, ladies and gentlemen, then you can go and read the extra paragraph there. What about appealable? Is a provincial sentence appealable? The common law does not provide the defendant with any right of appeal, but classifies a provincial sentence as a pure or single interlocutory order against which no appeal can lie. The decision to grant provincial sentence is not final in effect and is susceptible to alteration by the court during the principal case. So either the losing side, the defendant can leave it alone, or within 2 months he must decide that he's not acceptance goes in the final case. So this is very interesting, and a lot of people don't know this. Like I say, a lot of people don't use this. All right, so let's go on. What about in page 1.4 about the exception to provincial sentence not appealable? Well, let's have a look at it. We know you can't appeal it. In Smith v. Scania and Avs 2004 in the Supreme Court of Appeal, which is great. When you see SCA and you see CC, that's great. It was stated that it's possible in exceptional circumstances that provincial sentence may be appealable. So let's see. The following 2 examples of a quasi provincial sentence summons are found in Harms. Claim based on a dishonor check. Plaintiff is the holder of a check dated for the sum drawn by the defendant in favor of cash upon and branch of the specific bank, and so it goes on. A claim based on section 1 of the Act 34. Plaintiff is the true owner of the check. It tells you there what to do. The check was stolen by C and possession passed thereafter to the defendant who gave consideration for the check. The check was thereafter paid by B bank. Plaintiff suffered a loss equal to the value of the check. So they say there are 2 examples then where actually you can consider it, and they call it exceptional circumstances, but I call it also exception raised to the provincial statement that's not appealable. In other circumstances, it's not appealable. Let's have a look at the 2 young Gazelle judgment. The preceding contents of this chapter must now read in conjunction with and subject to the judgment of the Constitutional Court of South Africa. So that court case is rather important. Let's read it. The head note of this judgment reads as follows. Rule 8 of the Uniform Rules of the High Court. Provincial sentence procedures declared to be inconsistent with the Constitution. It's the same as summary judgment. And invalid to the extent that it does not give the courts a discretion to refuse provisional sentence where A, the nature of the defense raised does not allow the defendant to show a balance of success in his or her favor without the benefit of oral evidence. B, the defendant is unable to satisfy the judgment debt. And C, outside special circumstances, the court has no discretion to refuse provisional sentence. Common law developments show that courts will in future have a discretion to refuse provisional sentence so that courts will in future have discretion to refuse provisional sentence only in a circumstance where the defendant demonstrates A, an inability to satisfy the judgment, that B, an even balance of prospect of success in the main case on the papers, and C, a reasonable prospect that oral evidence may tip the balance of prospective success in his or her favor, declaration of invalidity not to affect any claim for provisional sentence that has been finally determined as at a date of the court's order by adjustment at first instance by the settlement. So please go and take cognizance of this court case. So it must be read in conjunction with whether it's appealable or not appealable, and that is also a very well-known case actually. All right, that brings that to an end. It actually brings summons to an end. It actually brings action procedures to an end. And how many application procedures that you see, interlocutory applications you saw that runs on the back of actions? Like, for example, the divorce case we are doing now, where you started with the action procedure, and suddenly in the Rule 43, we are dealing with a application procedure. So, on page 147, it's 11:01 now. At 11:30, we'll take that quick 5 minutes break. We have to get to page 160. That's where I need to end today, and it doesn't matter when I get there. If it's early, we'll stop. And let me have a look at that. Yeah, I think what we'll do is we'll stop on page 160. Yeah, that's good. All right, the application procedure starts on 147. Those people that did their homework, maybe read up a little about it. Michelle, who did very well there. I'm very satisfied, Michelle. Again, congratulations, you did it well. So most probably you found a good example out there somewhere, and you utilize that template to work from it, which is absolutely acceptable. Well done. So page 147, the application procedure. And now we're going to talk a little bit about that. But I've spoken so much about it that actually we might be in for a quick run through here. All right, introduction. Well, I'm not even going to go into the introduction, except look there in the introduction. You'll see application and motion are often used as synonyms. But that is not correct, because if you are in motion court, you bring your action applications also there, especially if they are undefended. So don't please, motion court and application cannot run as synonyms. That's what I'm teaching you. That's what I'm teaching you. All right. What is the background? An application consists of a notice of motion founding affidavit, together with any supporting affidavits or confirming affidavits or supplementary affidavits. We're going to go to that. It's in here. I gave you a quick run on it, but we're going to teach you more about precisely what it is. Although such an application is usually issued by the Office of the Registrar before it is served, it is not a mandatory requirement. Service of such an application before it is issued is not a nullity. You can agree with people in certain methods of service there. Please take note of that. Seeing that application on page 148, seeing that application procedure is much quicker and less expensive than the action procedure, it's often a consideration to rather approach the court for a necessary by means of application procedure. Now, we have shown you where you can do that and where you cannot do that. So at the end of the day, what is very important to me here is that it's cheaper, because the court can then, on the papers in front of them, they can decide a matter and they can quickly call via voce evidence. But in the action procedure, when you go on trial, it's a lengthy situation, and you've got to pay guys like us the big money to do it. Except if you have the right of appearance in the High Supreme Court, then of course, I think that is Section 25 of the Legal Practice Act, then of course you can do it yourself. And then again, I talk about the difference between application and action procedure. I'm not going to go into that because we had a very good table there. Do you recall? We had a very good table there, and I still told you to fix something in that table. Wasn't that correct, Fatima? I still asked you, Fatima, to show us what was wrong there, which indeed you did, and we fixed it. Manner of bringing the application before a court. Applications are brought in one of two ways. On notice to the registrar only where no other person is affected ex parte, like, for example, your application to become an advocate or an attorney. On notice to the registrar by another person affected by application and notice of motion. And listen to me. The notice of motion and the ex parte notice of motion is the bloody same thing. The only thing that differs is at the top. you say ex parte application, and then the court knows, it's not something that's in dispute. So please, everybody runs around, I can't find an ex parte, I can't find an ex parte. It's the bloody same thing. It just differs here and there, but you don't even have to worry about it. Instances where the use of the application procedure is mandatory are as follows. Yes, let's have a look at it. Where there is no dispute of fact, but only dispute of law or manner of the application of law. Examples of instances where use of application is mandatory. Appeals from one court to another, you have to do application procedures. Review applications, we did say that in a week, I recall that. And here it comes. Ladies and gentlemen, this is a good list. Rescission of judgment applications, interlocutory applications, interdicts, third-party procedure, joinder of parties, consolidation of actions, sequestration, liquidation, leave to sue by ethical situation, substituted service, appointment of a curator, admission as an attorney. And please put a dot there. I want to throw a business rescue in there. You can actually say sequestration / liquidation / business rescue / debt restructuring. How about that? You can put a couple of things in there. All right, so there you have the Hope case of 2006. You can go and read that yourself. But there's a nice list. And you cannot bring them on action procedures. Please don't even try to attempt it. There's just going to be a problem with that. All right. Instances when the use of the application procedure is prohibited, personal injury claim, motor vehicle accident claim, divorce matters, there you can only use action procedures. Right there. Only action procedures. Different types of applications. Yes, this is a nice chapter, isn't it? What do you think? Revelation? This is a nice chapter. It actually tells you it tells you better than that when we saw in the action procedures, because I still told you to pull a line through a sentence there that was extremely confusing. So what type of applications do you get if we have to group them? Applications by notice, ex parte applications, interlocutory applications, urgent applications, interim matrimonial applications like the Rule 43 you just did, and review applications. So they group them a little bit for you there. All right. Let's talk about ex parte application. You can page 250. It's 11:07. We will break at 11:30. If you don't need it, believe it, I do. All right, page 150. What is an ex parte application? An ex parte application is an application in which the applicant are not initially obliged to give notice to any other party. There isn't really a dispute. There's quite a lot of them actually. But the best example I'm going to give you is your own application to become a legal practitioner. Under what circumstances is this application utilized? An applicant may apply for relief by way of an ex parte application under the following circumstances. Where an order is sought that does not affect another person, and the applicant is the only interested party into the proceedings, and there they tell you admission as an attorney. Okay, I want to talk about that. Guys, you know that you cannot apply to become an attorney anymore. You know that your application to court is a dual application. You know that, eh? Especially for advocates. So first you apply to become a what? A legal practitioner. And the secondary part of your application will be to become an attorney or an advocate or a trust-bearing advocate. All right, just quickly there. Where notice of the application to the other party will frustrate the requested release, like an untold pillar application, that's ex parte. Where a preliminary relief is essential and there's no time to give notice, and where the respondent will give a notice once the urgent relief is granted before any final relief is granted. So that's common sense. You can see that can be done ex parte. Where final relief is required so urgently that notice is not possible, but in this regard, see paragraph 8.2 below. Where a nulla bona return is relied upon in the case of an application for sequestration, and no notice of the application is given to the respondent. Make a note there. Courts don't like this. I've brought a couple of them. Most of the judges is just like, I'm not comfortable doing it. I'm not comfortable doing that. And you can argue nulla bona return until you're blue in the face. Yeah, there's a lot of judges that does this. What you have to do is you actually have to bring this under their attention. You have to say to them that this is how it operates. But then there's always those that feel that you want to teach in their work, which you actually should sometimes. And then the last example, there's in certain very specific circumstances where it's not possible to give notice to the other side and or for a preliminary step in the proceedings. For example, an application for leave to sue by ethical citation or substituted service, or an application for the appointment of the curator. In any event, when you do these things, the court will allow it. And sometimes the court will even give you directions from what, so isn't that correct? All right, I'm not even going to take it further than that, because I believe we have spoken also to a certain extent a lot about it, and you can go through that. But now, on page 151, you've heard me talking about Rule Nisi. And I know a lot of you have been sitting there and, okay, we're not going to ask this question, it's going to sound stupid, which is not true. Nothing is ever stupid. No question. You are training to become and go into a very professional career. So you must ask questions, even if you think it's stupid, but I'm telling you, there's no such thing as a stupid question. And I still ask questions at this level. Don't think I know it all. I ask a lot of questions from guys more senior than me. All right. What is a Rule Nisi? In some instances, urgent relief is required by the applicant, but she recognizes that a judge will not permanently impact the rights of another party without that party having the opportunity to oppose a final order. All right? A Rule Nisi is the form of order which can be used in these circumstances. The application need not necessarily be served on the other party. At the outset, it commences as an ex parte application. Some interim relief, not final relief, underline that. Otherwise, you can't have a Rule Nisi. Some interim relief may be granted at the first court hearing, but the Rule Nisi will stipulate a date by which the respondent must show why the order ought not be made final, and the second hearing will take place in due course. The interim order and the application purpose will then be served on the respondent so that she has the opportunity of opposing the granting of a final order. That is a Rule Nisi. And that is what you need to know. So it's an interim relief. Please, guys, cannot be a final relief. It would be unconstitutional. Where an ex parte application has been launched and the judge is not prepared to grant a final order, it's like that nulla bona return. That happens a lot. As sought by the applicant, because the judge requires that the respondent be given the opportunity to oppose the application, the judge may elect instead to grant a Rule Nisi form of order. And there you have it. I ain't going to say more than that. I think you understand it. What is the format of the ex parte application? In an ex parte application, the notice of motion is addressed to the registrar. And there you can see it in one sentence. Ex parte application, notice of motion, bloody same thing. There is no other party interested in application. There will be no respondent. It must be supported by an affidavit as to the facts upon which the applicant relies for relief. Now, this affidavit in an ex parte application must be thorough. And in the pupillage program, I had a people as an exercise draft an application to become a legal practitioner and some kind of advocate they could pick. And there's so many court cases. I mean, you really have to put up a good affidavit there, especially if you think about this nulla bona return and things like that before the court will be amicable to giving you that order. So please, guys, for example, if you want to become an attorney and you have been sequestrated, placed under administration, or you had a criminal record, and I'm using the word had there because you can get rid of certain criminal records, then you have to bring it under the attention of the court. So when you do an ex parte application, when I do those for clients, I usually really hang out with that affidavit. The notice of motion is headed with the same of the name of the court. No, I'm not going to even read that. And then let's go there. Let's quickly go to your examples. Page with me to example number 17. Let's see if we can find that easy. Where I know we found 6. Oh, yeah, okay, I'm way too far now. What is that? Let's see if we can find it there. If you have it, post the number there. They have everything, your application for default judgment. 15, I'm on 15 now. There is 16. Oh, here it is. Page 223. You can go to page 223, notice of motion, ex parte. In the matter, you'll see this applicant, nobody else. And it's just a short thing there. And then they just say you've got to put a case number in there and the division number. So it's so easy to do it. It's a normal notice of motion. The only thing is you don't have other parties. All right. Okay, so that's the format then. Not going to go into that now. That'll be a waste of time. Let's page to page 152. Applications or notice to the respondent. All right, so now we finished with ex parte application. You'll see on the top of page 152, they say there, in ex parte application, good faith is an absolute necessity. Please underline it. You need to get that affidavit right. If any material facts has not been disclosed in the founding affidavit, whether they were willfully suppressed or necessarily omitted, the court may on that ground alone dismiss the ex parte application. And lying is out. You don't work for your clients. Well, you work for them, but you work for yourself. And you don't lie for them. So please be careful. If you bring an ex parte application, you must really, really, really do it right, Fatima, or there is going to be a problem. Okay, we now finished with ex parte application. We're going to normal applications now, where you have your applicant and your respondents, or more than one applicant and more than one respondent, whatever the situation might be. And this is precisely, of course, what you did in this Rule 43. All right, paragraph 3.1, page 152. We've got 40 minutes to go before that break. Let's see how far we can come. Under what circumstances is this application utilized? Well, for all those applications we've mentioned before, rescission of judgment, liquidation, sequestration, all of those things. The notice of motion is headed with the name of the court. Yeah. They talk about 15 kilometers there. I think we've said so much about it. It says for a day, not less than 5 days after service of the notice on the respondent, on which the respondent is required to notify the application right away intends to oppose the application. And there is an example. There is an example in your book of that. And the date, if no notice to oppose is received, when the application will sit down for no less than 10 days from that service. Care should be taken that every person who has a legal interest, underline that. I'm not going to talk about it further. I explained it to you where I told you that a lot of my attorneys sometimes argue with me because I cite every interested party. But if you read further, you'll also see that although you have to cite every interest party, they also say there that some has got really nothing to do with it. Although the interest party you mustn't cite. That's bullshit. I don't work like that. I cite everybody so that everybody knows. Because I have found in companies that one director, they fabricate a resolution. Other directors don't know about it. And then they bring applications behind the backs of other directors. So I cite all the directors. Everybody knows about it. And every now and again, you'll hear a director jump up and say, I was not in this meeting. Where did that resolution come from? I didn't agree to it. It's just the way I do business. All right. Procedure for bringing an application. Really? Do we have to do this? All right, we'll do a paragraph or two. If the application is brought against any minister, deputy minister, premier of province, blah, 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 a state in its capacity as such a state or province, this date should not be less than 15 days after the service of the notice of motion. After delivery of the notice of motion, the respondent must file his opposing affidavits within 15 days. The applicant may file his replying affidavits within 10 days thereafter. That is the DIS. If the respondent intends to raise a question of law only, he must give the notice of his intention to do within 15 days. That's that there. After he has given notice of his intention to oppose the application. The notice of motion must be supported by a founding affidavit, must be served on the respondent by the plaintiff. And in your notice of motion, you'll type the name in there. That the founding affidavit, this is supported by the founding affidavit. You only type in the name of the person of the founding affidavit because the supporting affidavits, the confirmatory affidavits, the supplementary affidavits, not at this stage yet, but in the future, and all the documents attached to it, they are annexures of the founding affidavit. Remember, in an application procedure, everything in an application procedure is annexures of the founding affidavit. All right, so that's important for me to tell you that. And of course, now we have to talk about a founding affidavit. And here we have to go a little bit slow. Very impressed with Michelle. Her Rule 43 founding affidavit was good enough for me. Her language was good enough for me. And of course, when I gave to you the homework yesterday, I was wondering what you're going to do with the prayers. But she did it right. In this instant, the prayers goes into the founding affidavit. But in most, 95% at least of your applications, the prayers do not go into the affidavit. They go into the motion, notice of motion themselves. Which facts must be set down in a founding affidavit? Let's look at it and debate it a little bit. The essential allegations and supporting evidence which must be set out in the founding affidavit include those necessary to support the contention that the parties have locus standi. And we spoke about it in the particulars of claim. It's the same. Don't worry about it, ladies and gentlemen. It's the same. You can almost use that template, not totally, but you can almost use that action procedure template I've given you. Those necessary to support the contention that the court has jurisdiction. Do you see it's the same? Those necessary to make out a course of action. It's the same. Those necessary justifying the relief sought. It is the same. So I've already taught you the template on the POC, and basically these 4 pointers is in the template. The only thing that I want you to write in there is that even before locus standi, a lot of people will put it under locus standi and jurisdiction. So you can either put locus standi and jurisdiction on top of it, or you can put locus standi and jurisdiction below it. I put locus standi and jurisdiction below it. So please just write there that you must set out the purpose of this application and make that number 1. That is how I'm teaching you. So before you move into locus standi and jurisdiction, you can do that, or you can do it in the middle or below jurisdiction, but you will definitely do it before course of action and before relief sought. Now, it's a few pointers, and it becomes 5 now when you put that in. You might find that the founding affidavit is not long. Most founding affidavits are very long. The confirmatory affidavits usually are low, Peggy, and so they're short. They're usually not very long. Supporting affidavits can be long, and then of course supplementary affidavits depends on amendments or something new you're bringing to the table. All right, I give you a court case there, so we're happy with that. Take notice of the following matters in particular. The affidavit must consist of paragraphs that are consecutively numbered, and every paragraph must contain separate factual allegations. Ladies and gentlemen, I advise again, put your paragraph numbers in the middle. Put your paragraph numbers in the middle. I've been doing it for years, and it works well. And when you get to your opposing papers, and your paragraph numbers are in the middle, and you add paragraphs run from the left. So that's kind of how I've been doing it for years. It's also very neat. If more than one factual allegation appears in a paragraph on page 154, it should be divided into sub-paragraphs. It is important to draft the founding affidavit in such a way that the respondent may simply refer to paragraphs of the application in his answer affidavit. So, for example, if you have your paragraphs chronologically 1, 2, 3, 4, 5 running down the middle of the page, when you break that paragraph up, let's say you're breaking paragraph 3 up to 3.1, 3.2 or whatever, those numbers you will take to the left. A lot of people leave them in the middle. That's just not neat. So you just keep your singular numbers 1, 2, 3, 4, 5 in the middle. But if you break up a specific paragraph into sub-paragraphs, you take that to the left. And remember, when you oppose your papers, you have to oppose it on every paragraph, the sub-paragraphs too. Okay, introducing the deponent. Let's see how you do that. It's basically the same that a POC. You're just not making short averments anymore. You're now doing an affidavit. You're writing a story. So your language is very relaxed. It's not as short and concise as in your POC. The affidavit in an application replaces the oral evidence led in a trial. So when we lead oral evidence in a trial, we ask questions and the person in the box explains fully. Now, on papers, you must do the same thing as though people would be testifying in court. That's why your affidavits are long and lengthy and bulky. A witness in a trial will be asked a number of preliminary. Okay, they say precisely what I'm saying. The full names of the deponent must be reflected, as well as the deponent's relation, connection, if any, to the applicant. The deponent may be the applicant. I'm not going to go into that because the citations I did under the POC, out of the Ambler's Pleadings of Harms, 8th edition. If you follow those guidelines in your application procedure, you'll be right. You'll be 100% right. So it's basically the same you did with the POC, and it's basically the same when you do it in affidavits. All right, now here is what is important on page 154. We won a court case last year. that went in for almost 7 years. We were busy with it. That second last paragraph on page 154, where an affidavit sets out facts based on second-hand information, the deponent must state the basis of his knowledge or belief, name the source of his information, and state that allegations of fact are true to the best of his information, knowledge, and belief. Failure to state the source of the information or grounds of belief in the founding affidavit is an irregularity that cannot be cured in the replying affidavit. The persons who have supplied this information to the deponent of the founding affidavit or to depose the confirmatory affidavit which are filed with the founding affidavit in order to convert such factual allegations from hearsay to direct evidence. You've got to mark this very important. Because last year, I had a lot of opposition in a case in Cape Town where I attached newspaper clippings. And that evidence amounted to second-hand information. Please remember that. And it's within the discretion of the court if they want to accept it. So a lot of people retaliated and say you can't do that because we didn't file a confirmatory affidavit from the person that wrote the article that will take it from second-hand information to which is hearsay to direct evidence. At the end of the day, the court said no. It's a public newspaper. They have no reason to, to not accept it. And within their discretion, they accept it. Hearsay evidence can become admissible in certain circumstances. We won the court case. So please take note of that paragraph. That paragraph is quite important for me. Now, the following paragraph that starts also there on the bottom of page 154 is very important. I have once lost a case on this. Where the deponent is not an applicant but acts in a representative capacity, for example, the director of a company, which company is the applicant, she expressly stated that she has the necessary authority to depose of the affidavit to bring the application on behalf of the applicant. So you bring it on behalf of the company, is the director. Where the applicant is a juristic person, it's advisable to obtain a resolution, I always do that, from the applicant authorizing the deponent to act in its behalf on deposing the affidavit. So that's very important. Failure to attach such a resolution to the affidavit does not render the procedure invalid, but if the deponent's authority is questioned, as invoked in Rule 7, proper evidence of authority must be proposed. So this is very important. That's a very important paragraph. Please mark that for me, NB. And it goes hand in hand with personal knowledge of the case. Please be careful of that too. They're not saying it here, but we read it in the week. We saw that. Please write there beside it. They must also confirm that they bring it on behalf of the company and that they have personal knowledge of the situation. And once I lost the summary judgment on that, I told you, I think, about it in the week. All right. So here they give you an example of a description of the parties. A voluntary association is described as follows. A voluntary association duly constituted in terms of the Constitution, where a jurisdiction has been created. The first respondent is a jurist who has as precisely 100% the same as with a POC. So please have a look at that. Yes, they go through the registered address and all of that. Representative capacities, respondents must be described in the same way. And on page 156, we're going to break in a few seconds, don't worry about it. In certain types of applications, there are specific additional requirements. That's at the top of page 156 to be met. For example, in an application for sequestration, the date of birth, identity number, material status of the person to be sequestrated, his spouse must be included. So those are things you have to look at. In the last paragraph I'm going to do before we break, the parties must be described with sufficient particularity as to identify them and whether or not they have the relevant locus standi. Addresses are required for identification purpose, but also in the case of the respondent to substantiate once the return of service is furnished, the contention that the respondent has received proper service and may also found the jurisdiction of the court. And I'm going to stop there. Let's break. Let's be back at 11:35 when I will open up for questions again. See you in 5. Right, guys, we are back. We are back, and we're going to take it home now. So, is there any questions? Peggy, Gomotso, Princess, Fatima, Sashin, Leona, Revelation, Michelle. Is there any questions? No questions. All right, before we go further, before we take home, let me just give homework for this afternoon again. And then hopefully we'll have a better result tomorrow. Michelle, I'm going to call again on you because you did your Rule 43. Guys, I want you to file your answering affidavit to the Rule 43. So tomorrow morning we'll just ask Michelle again. She did it so well. So how do you do it in application procedure? Precisely the same as with the action procedure. The only thing is you'll call it now an answering affidavit. So where you call it opposing papers, you've got other words for it. This is an answering affidavit. You built in that first paragraph to mitigate your risk. Bare denials are not acceptable, and you run it through. And you can even put in a counterclaim if you want to, although Rule 43, usually the courts will deal with that, and I deal with it on an urgent foundation. So what you can do there for me is just oppose it. Michelle, I hope you're happy with that. I'm not punishing you. I'm actually helping you, as you has done it so well. Actually, up to this stage, I think you're the only one who did it. So do your opposing papers there for me. If somebody else has done it, I'd like to have 3 people tomorrow again, and let's read that as opposing papers. So put yourself now in the position of the respondent, and let's see what you come back with. So tomorrow morning we'll be asking for opposing papers. And tomorrow morning I will also give again an opportunity to somebody that might want to say, well, I did opposing papers, I want to read my Rule 43 also, see if there's volunteers that wants to do that. Stick with it. We almost finished. Tomorrow's the last day. We're doing very well. We're going through the guide, and I'm giving my 5 cents worth on it out of my experience. And let's see that we can get you where you need to be going in your career. So right, that's going to be then the homework then for this afternoon. Just oppose that Rule 43, Michelle, and we're going to ask you first to give feedback on that, if you don't mind. Michelle, is that all right? Let me just talk to you. Is that okay? Are you fine with that?
It's okay.
Thank you, Michelle. I appreciate your positive attitude. And I'll be calling on people again, because I need these examples. So Angelique, Annerie, Fatima, Cecilia, Kutsia, Annerie Kutsia, I think is the same person, I'm not sure. I'll also be asking you tomorrow morning if you have done your Rule 43 and your opposing papers. It's in everybody's interest, and I'll be asking you that question. So if you've done it, I'll be happy if you give us feedback on that. So yes, those are people that did the homework. Daryl Olsen, I know you have a problem with your daughter. Hopefully they'll be fine. So I'm going to ask you also. We'll just need 3 people. We'll see where we can use. And I like to look at Linda Mkisi also. And so on. All right, guys, that's it. Let's go on. Let's take it home. We're almost finished.
Sir?
Yes. I'm listening.
Yes, unfortunately, I missed the first 30 minutes of the lecture due to a data problem. I want to understand something. Yesterday, I tried to do some research about this Rule 43 affidavit, but now I have discovered that there's a financial disclosure form that you have to fill. Am I right?
For what? For the 43?
Yes.
Yes, that is true.
Yes.
The Rule 43 is actually based a lot on those disclosures, that people can have access to bank accounts and things because people lie about it. I must admit that I don't see a lot of the attorneys of record still using it. I've seen it once or twice in cases that's been thrown in my direction. But yes. What is your name?
Katleo.
Katleo, can we have a Rule 44 from you tomorrow morning where you actually utilize that?
I need to first understand, because now I'm struggling. There's a case of E versus E where they said there's now a form that you have to fill, which is called a disclosure, financial disclosure, something.
Yeah, no, that's correct. What you have to do, Katlelo, can you go and research for us, because I'd like to have feedback on this from you. Can you go and research this? You're going to have to look at the rules of court, and you're going to have to look at legal practice directive. Legal practice directive. Tell me, where are you situated? In Johannesburg, obviously.
Yes.
Okay, so you're going to have to look at the Self-Gauteng legal practice rules, and you're going to have to surf the internet, because you might find it there. But yes, go and do research for us so that tomorrow, then actually what I'm going to do, I'm going to change your instruction. I'm not going to put pressure on you for a whole Rule 43. What I'm going to do with you, Katlelu, because it's not in the guide, and it should actually be in the guide, so you've raised a very interesting issue. Tomorrow, you're just going to have take about 5 to 10 minutes, and you're going to talk to us about that court case, print that court case, make a summary of it. The summary of that court case is usually in the beginning of the court case. You can use that, and you can go and look at the prayers, and then try and get that form for us, and then come and talk to us a little bit about that form. Would you do that for us?
I will try my best, because I found it. I have found it. It's a lot of work. I'll try my best. I
don't want you to draft the Rule 43. I just want you to give us a summary of the court case you refer to, and then I want you to source that document, and all you do is you tell us what is in that document, read through, tell us what you have to fill in there. Because, that is one of the new things that's also come out, and I see it's not in the guide. A lot of attorneys don't use it. What a lot of attorneys do, they still type in. Because, Katlelu, you use the same document, not the same document, but you use a relevant document also, a prescribed form when you do sequestration and liquidations. But it comes down to the same thing, the disclosure thereof. So, flipping, here in the afternoon, you guys are waking up. That's great. Okay, Katleo, we'll give you then a first opportunity tomorrow morning to tell us what you have. At the very least, you are going to give us feedback on a court case, because that you have. And then we'll go on to Michelle, and hopefully a third person will assist us with the Rule 43 and opposing papers. Are you happy with that?
Okay, I'll try my best.
Good for you, man. Good for you. Thanks for raising that issue. I appreciate it. And yes, everybody take note of that. A lot of attorneys still don't do it, but there's a court case on it, and he's going to tell us precisely what that court case is saying. And then, of course, when you do liquidations and sequestrations, there's also court cases that demands this kind of disclosure now. And yes, of course, this is under application procedures. So I'm very happy that KS has raised that issue. I'm very happy that Michelle says she's going to do the opposing affidavit for us. And then I need the third person that will come out on the Rule 43, read the Rule 43 in the opposing papers there. All right, guys. And of course, K is now excused from doing that. He's got a specific instruction. He's going to do a little of research for us on that. Yes, excellent, excellent. Here on the afternoon, 11:43, and some good stuff is starting to come through. All right, guys, let's wrap it up, shall we? Page 156. Exposition of facts and legal consequences which flow. All relevant facts must be stated. The rule is that the applicant must state his case in his founding affidavit. Now, I have a rule here you can write down there. Rather too much than less. Rather too much than less. The applicant must lay out his course of action in terms of which application is based. All the evidence that the applicant relies must be stated. The applicant's allegations must be restricted to those that are relevant to ensure that the applicant obtains the relief sought. Now, the word relevant, put a circle around the word relevant there. Where he fails to make essential allegations in his founding affidavit, he will not, as a general rule, be allowed to make it in his replying affidavit. So that's very important. Now, the replying affidavit obviously comes after the answering affidavit, and that is the third round. Why do I say you must circle relevant? Ladies and gentlemen, it must be relevant, but rather too much than less. I have found if you're too cautious in the application procedure, you muck the case up. Like I said, a judge said to me in court one day, I agree with you. The attorney started this whole draft totally wrong. Because I kept on saying to him, this is so unfair. If you look at a case, this is the situation. And he said, I totally agree with you, but it's not in the papers. We cannot canvass this. And he cannot make a order as to something that's not in the papers. And he shut me down. He says he has to shut me down. He was also very upset with the draft there. So relevant, yes, but more than less. The applicant may only amend the course of action by preparing a supplementary affidavit. We know that. Keep in mind that a court is asked to make factual findings on the papers before it, and the correct finding can only be made if the court is in possession of all facts. All factual allegations necessary for the course of action in question must be set out in the founding affidavit. Okay, now let's just stop there. I said it in the Rule 43.2. I want you to have headings, as much headings as you can in your founding affidavit. Locus standi, jurisdiction, factual submissions, relief sought, any affidavit you can possibly think of. I remember when I used to specialize in medical negligence, I had so many weird, the sequela, so many weird headings in those POCs. Those were POCs. So please, guys, when you set up your founding affidavit and you use relevant headings in bold, underline, then actually the court can also better follow the flow of your case. And it also makes it easier for the opposition to file an answering affidavit to what you have done there. Still there on page 156, whilst the applicant ought not to set out this legal argument in the founding affidavit, it is necessary to set out legal conclusion, which arises from the facts, based on the facts set out that the respondent has breached his contractual obligations. Okay. This is streetwise. Actually, I don't want to teach you this because it's totally wrong, but I do it. So I was asked last year to bring an application for a post-nuptial application. Not an anti-nuptial application, a post-nuptial application. So they were married for a while and now suddenly they want an anti-nuptial contract. We call that a post-nuptial application, anti-nuptial application. And it's brought under application procedures. Now, the Supreme Court of Appeal made a ruling on this. And they said you can do this, but you must adhere to certain requirements in front of the court. So at the end of my founding affidavit, I must not teach you this. I must not teach you this, but I am going to teach you this. I stated in my founding affidavit, and furthermore, I respectfully submit to this honorable court that this application complies with, and I set out the whole name of the Supreme Court appeal there, and I pasted in that specific paragraph in which the court says that they will approve such a post-nuptial contract if the following prayers and submissions and requests are bolded in there. Now, I do that at my level. You are not supposed to do that because most of the time, if it is opposed, it will go into the heads of argument. And of course, you have to file it on the deeds office. A couple of places you have to file such an application. But I build that court case in there. And I don't do it every day. And up to today, touch wood, up to today, in the few times I felt I wanted to do it, I want to respectfully educate the bench a little bit because a lot of them don't know how to do this stuff. They've just been appointed there. I suppose they're very lucky people. I've never had a problem. Maybe in the future I might pick up a problem with a judge to say, listen, are you stupid? This belongs to your heads of argument. But you only set up heads of arguments if it's opposition. But then a heads of argument is also an argument. It's a submission. So in another way, if you were in court, you would actually refer to that court case. You might not call it a heads of argument, but you will still submit that to the court. So yes, they say here that you know the legal argument, but a paragraph is kind of phrases to my benefit in the submission I'm making to you. So that's what I do, but it's dangerous. So sometimes I feel it's necessary, and I wanted to show the High Court here in the South Division that there is a situation there, and that that is what that court case said. So I did it, and I've done it a couple of times. So up to date, I've not picked up a problem, but it is definitely not the way things should be done. But independent thinking, that's why I'm teaching you independent thinking. I'm telling you, in some cases, I've just done my own stuff. And up to now, I've never been reprimanded. I've never really been embarrassed in court. But you have to be careful with this specific streetwise trick I'm teaching you. So what I'm doing, I'm actually saying to the court, most of the times if you do something like this, you jump up and then the bench would say prayers. And then you would say, yes, my lord, as per prayers 1, 2, 5 or 6. And he would say, granted. He wouldn't even ask you a question. And this is what usually happens when I do that. Because I've given it to him. He sat in his chambers, he quickly Googled it, or whatever he does, goes into his legal library, electronic library in the High Supreme Court, just check that I'm not talking nonsense. And literally in a motion court, when you jump up and you've done it right, he would say prayers. Say, yes, my lord, prayers 1 to 5, respectfully as the court pleases, and it's the end of day, it's 5 minutes, you're out of there. I'm not saying it's always going to happen like that. A little bit of streetwise there, but a little bit of danger there too. Another judge would say, well, are you an idiot? This is not a place for it. But there's no rule that says you cannot do it, is there? So, I've been a little bit of a vigilante in my way of doing things. And yeah, let's leave it there. I've told you, you decide. Going on to page 157, the applicant must set out the facts which justify the relief sought. Remember the necessary allegations to prove the claim. It is important that the applicant attaches all supporting documentation. That's important. Don't muck up your annexure numbers. Don't muck up your annexure numbers. Double check him, double check him, double check him. It's not open to the deponent to merely annex to his affidavit the documentation and request the court to have regard to it. No. Everything you annex, you must explain. Let me teach you something for those guys that wanted to come on my contract courses. There I explain under the National Credit Act that you can't attach documents anymore and merely refer to them. The National Credit Act is very strict on it. If you attach a surety to a National Credit Act agreement, as let's say as Annexure C, you have to insert a clause in a contract that says Annexure C is a surety to this contract, and it's between so-and-so, and it's a continuing coverage surety, it's a limited surety, whatever the situation is, you have to explain it. It's the same here. You cannot just annex and say the court must have regard to it. I've seen that a lot of people do that. You can attack that. You must explain its value. And then, of course, they end off there with, I therefore respectfully request the Honourable Court to grant the relief as set out in the notice of motion. So your prayers are in the notice of motion. Rule 43 is one of those we don't do. But if you were to put your prayer, Rule 43 prayers in a notice of motion, would you be wrong? No. But there's a trend that we just don't do it. But in most of your applications, you won't find the prayers in your affidavit at the end of your affidavit. The applicant may attach to his filing the so-called verifying affidavits when needed. We'll talk a little bit. I don't like the word verifying at all. Verifying is a confirmatory affidavit to me, so I don't like that word. You might go ahead and write there confirmatory, not supporting, not supplementary. Verifying is confirming. So you can write there confirmatory. I don't know why the heck he typed it in there. Excuse me for a second. All right, that's good. I'm back. These will be affidavits of persons who give evidence in their affidavits in which they briefly support the factual affidavits. He's got it totally wrong here. A verifying affidavit is a confirming affidavit. A witness is a supporting affidavit. That's why using the word briefly supported, I just want to mark this. As the national moderator, I'm going to have to attack this with the drafter. This is not wrong. All right. So write by verifying confirmatory, and right there where he says they briefly support the factual allegation, that is a supporting affidavit. Damn. Affidavit should not contain hearsay, inadmissible evidence, and any other objectionable matter, irrelevant or scandalous or vexatious matter. I've just taught you with hearsay, there is a way you can actually do that. All right, guys, I'm paging to page 158. It's just a book, guys. It's just a guide. All the books, the Bill of Rights, Ian Curry, Amblers, Chris Harms, my buddy, we're all just human. It's a book that was written. I will attack it if I don't agree with it. And when you have experience one day, you're going to attack the book too. Don't think because there's a guide in a book given to you that, aha, this is the way it must be done. Books as mistaken, especially in the legal field. You're going to become, I know, I saw some of you have got doctorals behind your names. So surely you must read some of these things and say, I don't agree with it. Surely in this week, I've said some things that you say, okay, all right, he's teaching that, but I just don't think so. You see, you're an independent thinker. It was a human that wrote this guide. It's a human that wrote the Bill of Rights book. Remember that. Tomorrow, you're going to be the human writing that book. Don't just swallow everything that people write in books. I'll never do that. That's not the way you should be. You're an independent thinker empowered by knowledge. It's just a book. It's just another human. And I don't agree with those 2 paragraphs I ask you to fix now at all. Page 158. The issue and service of the notice of motion. All right, well, let's go through it. All applications are issued by a Register of High Court, like a summons application, are served by the sheriff in cases where it's impossible because of time restraints. We spoke about this. I'm not going to do it again. I'm just going to say one thing to you again. Check that register. Check that guy that take that stamps and hits the table as though he wants to hit it through the table. Make certain he stamps it everywhere and make certain the stamp date is right. You've got no idea. Even prescription battles sometimes that impacted on. And the judge accepts the stamp. The judge accepts the stand. And you literally have to file affidavits and adduce evidence, because what is the judge supposed to do? The stamp's supposed to be right. So please, when things are getting stamped, say to him, hey, it's today the 13th. You still on the 12th, you idiot. Change that stuff. Don't call him an idiot, but that's how you're going to feel. All right, guys, so I'm not going to go further there. I'm going to go to paragraph 6, unopposed applications. That's nice. Notice of set down, they talk about ex parte applications. They usually unopposed. We already spoke about it. But they will not work for you if your affidavit is lacking. Instructions to the counsel. In the event that you decide to brief counsel, the following documents must be included in the counsel's brief. Copy of the application. If it is an application in accordance with Form 2A, where the respondent did not give notice of intention to oppose, a copy of return of service, a copy of the notice of set down. And then, of course, at a hearing, in the case of ex parte application, we know a person has been interested in the matter, the court may grant final relief. So please have a look at that. On page 159, as we are rolling into the end, we only have to go to page 160. We're still on opposed applications again there. Paragraph 7. Actually, we're starting with the opposed applications there. We just finished now, actually, with the unopposed applications. My mistake. Notice of intention to oppose. There's an example. Go and look at that. The next paragraph 7.2 there, Rule 65D. A person opposing the grant of an order sought to notice shall, within the time stated in the give the notice in writing to the applicant, he intends to oppose. They talk again about 15 kilometers, but I also talk about as such person's postal, fax, or electronic mail addresses. You can agree to that. And then they give you an example at 21. So I'm not going to page you to that. We know the example numbers work. They know they're right. So you have an example there. Then we move on now to the answering affidavit. That's the ad paragraphs we're going to see from Michelle tomorrow on Rule 43. And a couple of other guys hopefully will give us feedback there. So we're going to work with there. You see the 15 days there. The responder will in his affidavit clearly state whether they admit or deny the allegations of the relevant paragraphs in the founding affidavit. Where the respondent has a version to put forth, this must be set out. And remember, you can also put your version forth when you are finished with the ad paragraphs. Then you can just go on with your normal numbering and say you say. Remember, there's a replying affidavit that can come out, so that's fine. All right, so those things are all important. Counter applications. If a respondent requires more than the mere dismissal of the application and cost, he may bring a counter application or may join any party to the same extent. So we call that a counter application, not a counter claim. To the same extent as would be competent if the party designed to bring such a court application or join such a party where the defendant in the action and other parties to the application were parties to such an action. So you can go and look at that. On page 160, this is the last page we're doing for the day. In the latter event, Rule 10 shall apply mutatis mutandis. In practice, it means that the respondent who wants to bring a counter application usually sets out such a counter application in his responding affidavit. Ach, what the hell? Just write there in brackets behind responding affidavit, answering affidavit. Somebody had way too much brandy. Must be a triple, not even a double. In any event, so please just write the answering affidavit before I have a heart attack. Under the heading counter application, in other words, it's not necessary to file two separate affidavits. It's the same with the counterclaim. You can oppose your claim, and in the same papers you can do your counterclaim, or you can bring them separately. In my career, I've never had the necessity to break them up. Maybe there's a reason for it. There can be a reason for it. I don't know. If a counter application is brought, the time periods with regard to applications must apply. It's the same. A counter application must be accompanied by a relevant notice of motion. All right. So you don't have to break them up and all of those things. You can actually double your notice of motion also. That means you can actually deal with your opposing papers and your counterclaim in the same notice of motion. I've seen people do it and the courts don't mind. Now, the third time around is the replying affidavit. So we're going to come back with the replying affidavit now. Within 10 days, we serve upon him the answering affidavit. The applicant may deliver a replying affidavit. And now suddenly he refers to the answering affidavit. So maybe he became sober. The applicant will not be permitted to add new evidence in this affidavit. You cannot, which is not in the founding affidavit. For that, you need a supplementary affidavit. All right. The determined criteria is whether prejudice will be caused to the other party by introducing new information. I think you're tired of me and prejudice now. So if you've mucked up your case to such an extent that you cannot supplement it, well, you're dead in the water, or you're going to have to fight for your life. Further affidavits after the replying affidavit. The general rule is that the only 3 sets of affidavits referred to above are permitted. What are they? That is your founding affidavit, your answering affidavit, and your replying affidavit. The court may, in its discretion, permit the filing of further affidavits. Yay, at last. They say it blatantly. Leave to file further affidavits will be refused, where the party wishing to file the further affidavit cannot show bona fides, and that the delay will not be prejudice to the other party. At last, there it is. A litigant cannot take it upon herself, to file further affidavits without obtaining the leave of the court. Further affidavits filed without the leave of the court can be regarded as pro non scriptio, as it had never been filed. And that is it. That is it, ladies and gentlemen. We are finished for the day. Tomorrow is the last day, and I'm so happy that we were able to do everything in the guide. Tomorrow we're going to do the same, and then all of that. So, Katelu, I did write your name somewhere down now, Katelu. And then, of course, Michelle and somebody else. Hopefully, some of those old people that brought joy to my heart in the beginning. I'll see you on the dot 8:30 tomorrow morning for the last time. Thank you very much for joining. I'm out of here. It's 12:03. Have a safe afternoon, I think is appropriate to say.